Good morning, good morning, good morning. It is, well, May. It's May 1st. I can't believe it's May, but today we are going to jump back in time. We're going to just hop in the TARDIS and all go together, or DeLorean, pick your nerd. We're going to just choose a form of time travel. We are going to go back in time and cover day 4 of the Karen Read trial from Friday, 4/25. It is a short day. It was a half day in court. It's the day they did the jury view. It was a pretty quick day with only 2 witnesses. We're going to take a look at those 2 witnesses together. We're going to hear as best we can what the attorneys had to say about the jury view. We can talk a little bit about what a jury view is or is not and cover those 2 witnesses. And then we out because it's Metallica Day and I am unfocused and ready to go see Metallica. Emily, are you excited? I'm very excited. So as we get into day 4, if you have already seen day 4, thank you for no spoilers. I don't think there's any big spoilers for this particular day of court. It's, well, we'll get into the testimony, won't we? And then we'll summarize it. But day 3, remember, so as we jump back in time, day 3, we heard from, and I'm looking at my witness list because I don't remember, Daniel Whitley from the Canton Fire Department. We heard from the general manager of CF McCarthy's, the keeper of records for the Waterfall Bar and Grill, and then Mike Camerano. And then at the end of day 3, Trooper Garino came in and read those back and forth text messages between Karen Read and John O'Keefe back and forth, where it was like, are you coming here? I don't know if I'm coming here. Are you coming over? But the water heater, those text messages. So that's what we're coming into now is, after all those text messages, jury view, 2 additional witnesses, and then the break for the weekend. So with all of that, law nerds, we need to roll the intro. We need to go to court. We'll show the nails. I see it. We're gonna roll the intro first. We're gonna get organized. And then 100%. Hey there, I'm lawyer and legal analyst Emily D. Baker, and this is your go-to destination for live court coverage. I break down the law, the strategy, and the evidence in real time, so you know what's happening. No law degree required. So join the law nerds in the chat. They're here for the facts, not and let's get to court. All right, law nerds, are you guys ready to go to court? Are you ready to go to court? You're ready to see the nails. I know. Look, we did like Ride the Lightning vibes. That's what we were going for. They are some metal, they are some Ride the Lightning. That is the vibe we were going for. I do not know how to photograph nails well. That is what we were going for. That's what we were going for. That was the vibe. So are we ready to go to court? Law nerds, it's good to see you. It feels like we are back to like the regular law nerd chat. We are here. We are here for the law nerd chat. All right. Let's thank all of you. We're like, nailed it. Thank you. We had fun doing them. I appreciate it. It was just, we needed the Ride the Lightning vibe. Look, I am an OG Metallica girl from like, I don't know, 89-ish. Yeah, 89-ish, like elementary school. And then look, when the Black Album came out, I lost my damn mind. It has been, again, there are some music that has been a part of my life. I am very much an individual that enjoys music. I also grew up playing the drums. Metallica feels good to play, but it's also like a freaking workout. It's just love, love, love. So my heart is so happy. We are taking my teen. I'm just so excited. So live music keeps me going. I wish I was more musically inclined. I'm a much better talker than singer, so we're just gonna stick with that. So today we're gonna go to court and we're gonna slog through. Kimberly G. NYC said the late 1900s. Yes, I feel like now I'm like, look, children, step off. I'm from the 1900s. Oh my God. Okay, one story. My son was at his like first camp for his DCI troop, which is a band thing. And again, I love a good band. I love some marching band. I love all of it. So a full DCI moment. And one of the one of the older core members came back and is assisting the core and was saying that the first time he had seen this particular core perform was in like 1968. And he was like, look, you weren't around in 1968. Your parents weren't around in 1968. And I was like, oh, Heart, thanks for acknowledging that. Thank you for acknowledging that we weren't born yet. Because it's so rare that things happen anymore that I'm like, no, I wasn't born yet. Because like, cheers. And so Travis was telling me that in the car on the way back. He was just like, he's like, you weren't born yet. Your parents weren't born yet. I'm like, yes, love it. I love it. Y'all don't feel old in the chat. Look, we are wise. We are wise. And I'm going to continue to joke about feeling old, mostly because my knees. Tearing my ACL way back in the day hasn't helped. It hasn't helped. Anyway, so it was so funny. It was so funny. I love seeing, some of you were like, I saw Metallica in 98. I mean, Metallica in 98 would have been a 10 out of 10. I remember when we saw The Offspring in maybe 96, 95, 96, it was, concerts were different, man. The 90s was just different. It was just different. It was so much fun. But at one point they had a keg of beer on stage that they were like spraying onto the audience. And that's immediately when we ran away. I immediately ran to the back. I was like, I'm going to go home. I'm going to smell like beer. I'm going to be slaughtered by my parents and strung up in the backyard. Immediately no. Like the girls running away from the pit. Me. Bye. Just bye. I know today talking about concerts is going to be more fun than what happened in court. I promise you it's going to be more fun than what happens in court. But I'm glad we're here together. And then I don't have to keep answering the comments that say, I'm missing day 4. No, it's coming. It's here. Day 4 is here. Woohoo! I love seeing you guys share your first concerts. Look, we are concert people. And we love it. Live music makes me happy. Okay. Let's get dangerous. No, let's go to court, shall we? Are you ready, chat? It's time to,
bring the jury.
Let's go.
All persons having anything.
Oh, I missed the very beginning of the hear ye's. My apologies. I had to back that up.
Hear ye, hear ye, hear ye. All persons having anything to do before the Honorable Beverly Canoni, the Justice of the Superior Court, holding in Dedham within and for the County of Norfolk. Draw near, give your attendance, and you shall be heard. God save the Commonwealth of Massachusetts. This court is in session. Please be seated.
For the record, before the
I might just need, chat, let me know if we need this. I might just need a bumper with these hear ye's to just play every morning, and then who cares what happens in court? Because that was the most Massachusetts pronunciation of Norfolk I've ever heard. Sorry, Norfolk. I can't even. Norfolk, I can't. I say Norfolk so Virginia, but the slow pan with the hear ye's, this is probably the best hear ye's we have. I feel like we should stop just trying to find the hear ye's and just use these. I'm going to do it one more time. These are by far the best hear ye's of the trial so far. Chat, motion granted for a second round of hear ye's.
Hear ye, hear ye, hear ye. All persons having anything to do before the Honorable Beverly Canoni, the Justice of the Superior Court, holding in Dedham within and for the County of Norfolk. Draw near, give your attendance, and you shall be heard. God save the Commonwealth of Massachusetts. This court is in session. Please be seated.
For the record, before the court is Commonwealth versus Karen Reed,
Perfect.
22 CR 117. The parties are present. Our 18 jurors are present. The matter is on for trial.
Thank you very much, Madam Clerk. Good morning again, counsel. Good morning again,
There were like 2 days where they had a backup clerk because clerks have lives too, so for sure.
Ms. Reed.
Good morning, jurors. When we leave you out there, we're very much aware that we're leaving you in another room waiting, but we were working this morning to help streamline things and we were successful, so we do appreciate your patience. I do have to ask you those questions. Were you all able to follow the instructions and refrain from discussing this case with anyone since we left yesterday?
Yes.
Everyone nodded affirmatively or said yes. Were you also able to follow the instructions and refrain from doing any independent research or investigation into this case? Everyone said yes or nodded affirmatively.
Chat, you guys
Did
are
any of you
just
happen to see,
hilarious.
hear,
10
or
out of
read
10.
anything about this case?
I'm surprised they don't mention
since we
T
left
or
yesterday?
John Adams. They managed the entire honorific without mentioning
All right,
T or
folks,
John
as you
Adams.
know, this morning we are going on a view. And a view is
Field trip. Look, if I was on a jury and they were like, we're going on a field trip, I would just be I'd be like, field trip, adult field trip. I mean, maybe that's why I like road trips so much. They kind of feel like a field trip, but field trip, like field trip. I'm ready for a field trip. Let's go. Which is all the more ridiculous when yesterday we have jumped back in time. So it's fair to say it's May 1st. So we are going into, as I'm covering this, we're going into day 8 of trial. So for the future historians of the world that are watching this back, I will talk about things because we have time traveled. But it makes it all the more ridiculous that the jury has now been to 34 Fairview. They have seen 34 Fairview. And Jen McCabe's like, I mean, I guess you could call the yard flat. Ma'am, they've walked around Fairview. They've seen it already. They know what the yard looks like.
is simply, we're going to a place that you've heard about and that you will continue to hear about during the course of the trial. The purpose of the
Yeah, you
view
will.
is to help you better understand the evidence, which you'll hear during the course of the trial, and to help you appreciate the location and its surroundings.
Like the relative flatness
so the
of the
view that
yard.
we're going on is part of the case, and it means that the observations that you make there can be used and considered by you in your deliberations on this case in reaching a verdict.
The observations.
So we're going to, you've heard, 34 Fairview Road in Canton. The lawyers and I will accompany you. For the Commonwealth, we'll be accompanied by Attorney Brennan, and ADA Lally, ADA Schillinger, and for the defense, Attorney Yannetti and Attorney Little. The lawyers will have the opportunity, Mr. Yannetti and Mr. Brennan, have the opportunity to point out various things that they may want you to direct your attention to. Otherwise, there's no conversation between the lawyers and the jurors. So it's simply in a few minutes, you'll hear a little bit from each Mr. Brennan and Mr. Yannetti about what they want you to look at. And then when we get there, they'll direct you, look in this direction. They won't be able to testify to you, but they'll direct you on what they want you to look
They
at.
can point things out.
While you're in the view, you're not to take any notes. You're not to take any pictures. You're not to conduct any independent
experiments.
investigation at all during the view or any time during the trial. You're not to return to this scene or ask anybody to go back there for you. Today's your chance. You'll see
don't
photographs
drive
during
by
the
it,
course of
right?
the trial, I bet. But today's your chance to really look at everything. So the best way to summarize a view is that your job is to simply stop and look.
Collaborate and
It's
listen.
really no more
Us back with a
complicated
brand new
than
invention,
that.
something.
So your
Grabs a hold of me
responsibility is
tightly.
to see the place, observe it carefully, and to remember what you see.
Next time we'll do
Now,
Spice
during
Girls.
the trip to and from the view, and while at the view, you're not to discuss this case or anything about it with other jurors. We'll be accompanied by court officers who will direct you. And the court officers are there for all of us. So you'll be under their supervision until you're returned back here. So that's basically it. We'll be leaving in a few minutes, but first, before Madam Clerk swears the court officers in, Mr. Brennan, do you want to make a view opening?
May I?
The
Please.
way the
Thank
court
you, Your
said
Honor.
stop was just
Good morning,
too
ladies and
perfect.
gentlemen. As Her Honor explained to you, we're
Oh, a few of them actually said good morning to Hank Brennan. Well, that's nice. We'll see if that changes by closing. It's nice that they actually said good morning.
going to go to 34 Fairview Road. You have some exhibits that are already in evidence. You haven't had a long time to look at them and study them. But essentially, we're going to go to 34 Fairview Road. I ask you to pay attention to the street, the front yard of the home. And you'll see to the left side of the front yard in the corner, there'll be a car. It's the Lexus that we've spoken about, the defendant's Lexus. And you'll also see a flagpole and a fire hydrant. And so I'd ask you to take a look from different vantage points. Take a look from that area where the flagpole is, from where the fire hydrant is. And you'll see on the street before the grass is a little firm, concrete that comes up a little bit. I'd ask you just to note that as you go there. One thing I'd suggest is April 25th, 2025, not January 22nd, 2022. So the weather will be very different. The temperature will be different. The conditions will be different. We're going to go there probably at 10 o'clock. It won't be the same visibility. It won't be the same elements and the same weather. So keep that in mind when you're looking around. When you look at the lenses, a couple things I'd ask you to look at. There is some evidence already of photographs of the right rear tail light. When you look at that tail light, it will be different than the photograph that is in evidence. It has been removed, so it will appear differently, and you'll later hear testimony explaining that process. Also, I'd ask you to make a note on the Lexus about the height of the bumper. I'd ask you to make note of the height of the right rear tail light. And I'd also ask you to take note of, on the top of the hatchback, there's a part that protrudes. I'd ask you to look at that as well. Thank you very much.
All right. Thank you, Mr. Brennan. Ms. Giannetti?
Thank you, Ron.
So we know from the prosecution what they want the jury to take a look at. They want the jury to pay attention to the Lexus, to the right rear tail light, the height of the bumper, the height of the hatchback, the note that the visibility is different, I think is obvious, but it felt necessary to point out. These are local jurors. There's a reason there are local jurors. It's because they understand where they live. Arguing to me about the relative snow in Massachusetts doesn't help. I don't really remember from college because I wasn't driving. Like, driving in the snow wasn't even a thought to me. I didn't have a car. So it was just like, wait a second. You mean you all go out into like fields, but like kegs out here and just hang out? Okay. Love it. Everything's cold, but I'm not from Massachusetts. I'm not local. So telling them that the weather in April is different than the weather in January feels obvious. It feels obvious to me. But they wanted to point out the visibility is different, the weather's different. Take a look at the flagpole, take a look at the fire hydrant, take a look at the Lexus, take a look at the height of the bumper and the height of the berm on the car. Just take a look. So the jury will be going on The View. All right, let's see what the defense would like the jury to pay attention to.
Good morning. As I told you at the start of the trial, my name is David Canton. I have an office in Boston and in Garrey.
I'm local, y'all, just like you.
And
Call me if you need anything.
My co-counsel, we will be accompanying you on the view that you will take. Although the view is not evidence, I suggest to you that you will find it to be helpful, important, even necessary as you later do your investigation of this case within the four walls of this courtroom.
They can't do an
You've
investigation.
already received into evidence, some photos and videos, but there is no substitute for your own two eyes. As we all know, photos and videos sometimes can be misleading in terms of relative distances, depending upon the perspective from which the photo is taken. But your eyes are the best computer that you could bring to the view. When we get to 34 Fairview,
Okay.
we will be pointing out certain things that we'd like you to observe. The house, the second floor window to that house, the three front doors in the front of the house, the driveway, the street, the front lawn, and the flagpole. And we'll be asking you specifically to consider the distance between that second floor front window and the front lawn. The distance between the front doors to the house and that front lawn. The distance between the driveway to the front lawn. And we'll be asking you to take a good look at that Lexus. Just stand next to it. Just size it up. To take it in.
To size it up.
You were all selected as jurors
That's
because
close.
the parties entrusted that you would do a proper investigation of this case within this courtroom. On behalf of Ms. Reed, we have every confidence that you will do a proper investigation.
Oh,
Thank you.
sir,
All right.
you can't. The attorneys completely stepped away from the mic in front of the jury, which makes it hard. You will do a proper investigation is not really a proper opening because the jurors aren't allowed to investigate. They're only allowed to observe. They're not allowed to say, like, look at each other. And I have not seen this jury. We will not see this jury. So this is all hyperbole from me. But if there was a juror that looked about 6'2", they can't look at the 6'2" juror and be like, oh, go stand by the Lexus. Let's see like where the Lexus squares up on your body. Go stand next to it. We're gonna run a little experiment. Let's like roll down the lawn and see. They're allowed to observe. They're not allowed to investigate. And the defense made a few references to your investigation. I understand that it ties back into their opening. I think it was better placed in their opening when they say you will pay better attention to this case than the investigators did. But asking them to investigate is tenuous. It's tenuous. Because you're almost inviting improper jury behavior. They can't investigate. They can't just grab their phone, go drive around and see if it registers steps. And they might be tempted to. So ending the opening with you will do a proper investigation is rough.
Jurors, I have to make something very clear. So the purpose of this view is to help you better to understand.
And it's just going to piss the judge off more. And the judge is like, I just told the jurors that they can't investigate. And now you're standing up here saying you'll do a proper investigation. And the judge is like, okay, now I have to tell you again, you can't investigate. It pushes the line.
Understand the evidence that you'll hear.
No wonder the judge is just like,
All right, jurors, I have to make something very clear. So the purpose of this view is to help you better to understand the evidence that you'll hear during the trial and to help you appreciate the location and its surroundings. The view you'll take is part of this case. The observations that you make while on the view may be used and considered by you in your deliberations in reaching a verdict. So at the end of the trial, when I explain to you what is evidence and what is not, I'll remind you that your observations on this view can be used by you in your deliberations.
Which is why
also,
she reread that
while you're in the view, the same way you're not to
Observations.
take any notes or photographs, you're not to conduct any investigation on this case. You really are simply to stop and look.
Stop.
Okay?
Collaborate.
Those are the instructions. We will see you in a few minutes. All right? Thank you. Oh, sorry. Madam Clerk has to swear in the court officers.
You could all raise your.
she wouldn't have reread the instructions if Yannetti had said, we trust that you will observe 34 Fairview so you understand the testimony that comes in. That would have been completely fine. But saying and ending it with, we trust you'll do a proper investigation is rough. It's rough. The first time he said investigation within these four walls. But the second time he said it, we trust you will do a proper investigation.
Your right hand, please. Do each of
The
you solemnly
defense is
swear that you will
really
take the jury
pushing
upon the premises
the lines
in
this
question
trial.
and there suffer them to view the same or any property, place, or thing bearing upon the issue in the trial as the parties may think necessary? That you will not permit the parties to enter into a debate in the hearing of the jury, nor any person to speak to them unless it be the attorneys of record, then only to point out such places or things as they may deem expedient for the determination of the issues. That you will keep the jury together until they shall return to court, unless the court shall otherwise order, so help you God. Thank you.
All right, thank you.
All right, please. Just follow me.
I understand more and more why the court is so frustrated with the constant pushing of the line. Yeah.
Goodbye.
When it's back in session, maybe.
Also, thank you to Team Baker for making sure that I don't have to zoom through all the breaks. I very much appreciate it.
Who is your next witness?
Your Honor, the Commonwealth called Dr. Garrey Fowler to the stand.
Thank you.
Well, there we are. James Randolph said, I thought it was just poor wording. Sounds like EDB thinks it was on purpose. I don't think his use of the word investigate was accidental. He said it twice and they said it in their opening statement. I don't think Iannetti was fumbling for words. I think he's trying to tie it back to the theme of their opening. I don't think he's trying to suggest anything other than this wasn't investigated by law enforcement. You need to find the truth. But when it comes to the jury view, it's a bit different and can be read as you are asking the jury to do exactly what they're not allowed to do. I think he's trying to turn it into their opening, which is, as jurors in this case, you need to seek the truth. But there's a way to say that when you're talking about a jury view and say, we need you to be observant. Pay attention to what you can see. Pay attention to the yard, this or that. That's not what he said. So, and now we hear Mr. Lally with the next witness. So, what, if any, questions will be asked by Attorney Lally? Also, this is all complaints from an attorney on the internet who knows the difference of what you're allowed to ask the jury and what you're not allowed to ask the jury. The jury may be like, okay, the judge said we can look at things. Fine. Like, it's not a deal to them, I don't think. I don't think it's a huge deal for the jury. But as these things are building, I think it helps explain the frustration that we're seeing from the judge. Because it is thing after thing after thing. I'm not saying I don't think there have been things on the part of the Commonwealth, but on the part of the defense, there are also things. All right, let's continue on with witness number 9 in this trial from Friday, April 25th. You guys can keep talking about your first concert in the chat. I'm not going to tell you to stay on topic for this.
Do you solemnly swear that the
slog
testimony
through it.
you shall give to the court and the jury in the matter now pending shall be the truth, the whole truth, and nothing but the truth, so help you God?
For those of you asking in the chat, no, in real time, there's no court today. Sure. So we're catching up on Friday the 25th.
Good morning, Doctor.
Good morning. Good morning, Laura.
All right, Mr. Lally, whenever you're ready.
Thank you, Your Honor. Good morning, sir.
Good morning.
Could you please introduce yourself to the jury, spelling your last name for the court?
My name is Dr. Garrey Fowler, F as in Frank, A-L-L-E-R.
And what is your occupation?
I am a physician pathologist.
And where do you work?
I work currently at Signature Healthcare in Brockton.
And how long have you worked at Signature and in what capacity, sir?
Signature, I started, it's probably 6 months. I took a new job 6 months ago. I am the chief of pathology and the laboratory medical director at Signature.
And where did you work prior to your work at Signature about 6 months ago?
Prior to that, I was at Good Samaritan Medical Center in the same capacity.
And how long did you work at Good Samaritan for?
Since 2015, late 2015.
And did you work in any
Sir?
capacity similar to that prior to working at
It's okay to not eat the mic. It's okay to not eat the microphone.
Good Samaritan?
Prior to Good Samaritan, I worked at the Carney Hospital, which is in Dorchester. Started that job in 1996. So I stayed on staff at Carney Hospital up until actually closed 6 months ago. So I've been on staff at Carney's for quite a long time.
Where did you go to school and what degrees did you receive?
I went to college at Tufts University in Medford, graduated in '87. From there, I went to Tufts Medical School and graduated in 1991.
And following your graduation, where did you go from there?
After medical school, I did a residency at Tufts Medical Center in 1991 to 1996.
Oh, no, that wasn't the judge signing.
And
That
where
was
did you
me.
go following your residency?
I was signing.
And right from residency, my first job was at Carney Hospital, which I previously mentioned, so 1996.
And doctor, are you board certified?
I am board certified in anatomic pathology and clinical pathology.
And what is a board certification?
Board certification is
boy.
something we need to show that we are actually qualified to perform our the job that we need to do, both in anatomic and clinical pathology. It's a written exam that we take and we need to pass to demonstrate that we're competent and know what we're doing.
First, in
I
just general
warned y'all we
terms,
were
if you
gonna
could explain to the
slog
jury
through
what
this
is
today.
pathology?
Pathology is well, there are
Different
two
kinds.
basic branches of pathology: anatomic pathology and clinical pathology. Anatomic pathology is basically, an anatomic pathologist is a physician or MD or a DO trained to make diagnoses on patients via looking at tissue biopsies, organs, tissue fluids, and we're also trained in autopsy pathology as well. So basically, an anatomic pathologist, we look at tissues via glass slides. Slides are made, and we every day make the diagnosis of, somebody has a cancer or somebody doesn't have a cancer, benign. Look at colon polyps, breast biopsies, pretty much anything that comes out of the operating room or a physician's office, any sort of biopsy. Clinical pathology, on the other hand, is basically a clinical pathologist is a physician, an MD or a DO, who specializes in the clinical lab, which basically is any fluid specimen, including blood specimens. When you go to the hospital and you have your blood test and it gets sent to the lab, the clinical pathologist is ultimately responsible for the quality of your lab tests and quality, and basically that's it.
Okay.
And so the time that you worked at Good Samaritan, did that cover the date
we're
of January
at normal
29th,
speed.
2022?
Yes.
And again, what was your title and what was your
It sounds like all of you are
job
like, we could
at Good Samaritan in the month of January 2022?
zoom a little faster.
I was the chief of pathology at the time and laboratory medical director.
What did you do as the laboratory medical director?
Laboratory medical director.
Chat, motion granted to go to 1.25 as we, to go to 1.25 speed as we are moving through this testimony, background, training, and experience. Pathologists look at information and make decisions, but this is all background, so we're going to get through the background. It's important. It's a necessary part of trial. Is it anything the jury's going to remember? No, it's foundation. It's fine.
Basically,
Just fine.
the laboratory medical director is responsible for
That's
the ultimate
better.
quality of
That's
any,
much better.
either whether it's a
Good suggestion,
biopsy,
chat.
somebody's biopsy, or lab result. The laboratory medical director has to make sure that the final result is of excellent quality. So there are many different things that we need to make sure that things that are in place, as far as need to make sure we have the correct amount of workers. You want to have enough workers. You want to make sure they're competent. So as many, there are policies for competency for all the lab techs and phlebotomists and even pathologists. So basically,
I know,
the
the jury
laboratory
has to sit
medical
through it at
director,
real time.
if something goes wrong, it's ultimately his or her fault.
They went on a field trip and had to sit through
And
the
the lab
background
of Good Samaritan, is that lab accredited?
Great.
Yes, it is.
Good,
And by
Sam.
what body?
Lab accredited.
We are accredited, or Good Samaritan is accredited by the, we call it the CAP. It's a College of American Pathologists. They are considered the preeminent accrediting body for hospitals. They've been around for probably 70 plus years or so.
What is accreditation? What does that mean?
Accreditation is basically something that says that your laboratory is following guidelines and providing excellent quality. To be accredited with the CAP, every 2 years
The
we
lab
have
at Good Samaritan's accredited.
laboratory inspection.
Okay.
They don't tell you when they're coming. They will give you a 3-month window, and they'll come and inspect you to make
really
sure
simple
we
questions at this
are
point
of
from
have a good quality lab. Each section of the lab, pathology, the clinical lab, microbiology, chemistry, hematology, the CAP has a checklist with numerous requirements that one needs to fulfill. There are probably over 3,000 items that they look at.
And was
Good
your
Samaritan
laboratory,
lab
Good
accredited.
Samaritan, was the accreditation up to date on January?
Why does it matter? Because they took blood from Karen Reed, and eventually that blood had a retrograde extrapolation to determine what her BAC could have been, would have been when she was driving, and then what it was at the time they took the blood. Why is this different? Because the hospital was taking her blood for medical treatment. It was not a forensic blood draw done with a warrant subsequent to like a DUI investigation. So the way her blood was drawn was different than in a typical DUI investigation. And that's why we are going through the lab processes and procedures. I think this was more relevant in the first trial, because in the first trial, they didn't put in any video clips of Karen Reed talking about her drinking and driving. I think her drinking and driving has been established by her own words in this trial. So I think this is still necessary, but I think that the points the defense are going to make might be less impactful on the jury because of Karen Reed's statements about her drinking and driving.
January 29th, 2022.
We were accredited.
They were accredited. Great.
Now, in Good Samaritan Medical Center, when a blood test is ordered, what types of things is the lab testing for?
I think the most common tests that are performed when you go and you have your blood test is one is a chemistry test where we sodium, potassium, chloride, glucose. We also a common test is a CBC, or a complete blood count, where we look at
all the
your
shit
red
they do
blood
on Grey's
cells
Anatomy.
and
That's what
white
we
blood
do.
cells and your platelets. Those are the two most common tests.
And
Or a
why is
hospital.
blood testing ordered in the course
We
of
look at your
medical treatment
blood.
at a hospital?
When you're admitted to the hospital, usually you're sick. So
You need to know
the
what kind of
physician
shit's
is
happening.
usually a standard, ordering chemistry and CBC to see if there are any clues in those tests that could help the doctor.
Why do you
take care of
blood work?
If they look at a BUN and creatinine, maybe if they're elevated, you either could be dehydrated or have renal failure. If you look at liver function tests, maybe there's something wrong with your liver. So it's just a general, a good look at the patients to see if there are any clues that could help them.
And as far as the blood testing results are concerned, how does that assist either a doctor or a clinician in treatment and diagnosis?
More information's
Basically
good.
what I just said, if there's nothing.
His brain buffered. It's like, why would a doctor do that? And he's like, What? I just said why doctors run blood. Did you listen to me? Like, scratch that question off the notepad. Per my last statement, more information, better.
If the results are normal, that sometimes helps too. Rules things out if they're normal. If they do a CBC and look at the hemoglobin and it's low and patient's anemic, maybe the patient might need a transfusion. So there are many different case scenarios where the results can help the provider.
It's
clinician.
true. We know that Lally
Now,
does
with
live by
reference
his list.
to alcohol,
He does.
Does the Good Samaritan Medical Center, do they also test alcohol within the blood?
Yes, we do.
And why would that
But it's
assist
smoother.
medical treatment and diagnosis?
I think if a physician is wanting to know if somebody's been drinking or has alcohol on board, or maybe not, maybe that patient has ingested
Narcotics.
drugs of abuse. So they'll test for alcohol to see, one, if it's positive, and if it is, then it helps confirm that the patient has been drinking.
Now, are there any policies and protocols at Good Samaritan Medical Center with reference to how blood is taken and how blood is tested?
Yes, we have numerous policies. We have one policy specifically for phlebotomists. Those are laboratory technicians who draw the blood. So we have a policy for them to explain exactly what they need to do.
This is the part that's important.
And also in the laboratory, we have numerous policies basically for any tests that we provide. And so we have a policy for alcohol testing as well.
Chad,
May I approach
as
the witness,
always,
John?
your timing is impeccable. He did say alcohol on board. He meant, well, medical. He's talking about if you have alcohol in your body.
Two sets of documents. Just ask you to
Or if
review
you
those,
had,
generally, when you finish.
Anything else that might cause an interaction. So he's going through
Do
the
you recognize what those are, sir?
blood draws.
Yes.
And can you explain to the jury what is contained within each of those two sets of documents?
Oh, no, those are going to be the policies and
The first
procedures.
one is a patient preparation for specimen collection. This is the policy that I was mentioning, specifically designed for our phlebotomist to detail the procedure of the blood draw. Basically goes through one of the most important parts of the process is correct patient identification, where we need to correctly identify the patient. We have the patient state his or her first and last name and state it out loud to make sure it matches which the patient that we're trying to draw. And then we also match up the bracelet to the medical record number on the patient's
You got to
bracelet.
match
So,
the person.
one of the most important things is correct patient identification. The rest of this policy goes on and just pretty much details
They need the right person.
what to do next, including finding the veins, cleaning the site. It has some information on if there are any complications. So it's basically the entire process of the blood draw. The second one is our alcohol policy, which pretty much details in detail what goes on behind the scenes for an alcohol blood test in our hospital.
May I approach again, Your Honor?
Yes.
So those are the policies and procedures again.
Your Honor, call seek to introduce in the minutes the next two exhibits.
The way that the blood was drawn and for what purpose, and then being used for a different purpose, will be an
Your Honor, for the
issue.
record, it would be
of
the
contention.
patient preparation for specimen collection. The next exhibit in line.
So they are introducing the policies and procedures into evidence. Yes, you are not hallucinating. That is
ETOA
Adam
policy
Lally
would
doing
be-
the direct examination. I wonder if he'll do other experts or if we'll see him doing the direct of other experts. One of my criticisms last time was that the work wasn't shared at all. And it is a big trial with a lot
Doctor,
of witnesses. It's nice
What
to
types
see.
of precautions are
the
in
work's
place at
being
Good
shared.
Samaritan with respect specifically to alcohol testing?
And it's a good tie.
Well, I should say
I'm not
taking
mad
the
at that
alcohol,
tie
taking the
at
blood
all,
sample from the
Lally.
patient.
Yes, one of the major things we need to do with taking somebody's blood for alcohol is to obviously not use an alcohol swab. Normally, when you have your blood test, they cleanse the area with a swab that contains alcohol. So in our policy is a specific statement that says, do not use alcohol swab because potentially, when you're drawing the blood, if you suck up some of that residual alcohol, you could cause a false positive. So we have in our policy, and every hospital should have the same policy where we use a swab, a swab that has no alcohol. We call them a moist towelette. That's what we refer them to.
The
Also,
moist
in the emergency room,
towelette.
my supervisor pretty much removed probably 95% of all the alcohol swabs. So just in case a phlebotomist forgets to not use an alcohol swab, they are hard to find. We need to keep a few there because we need to use alcohol wipes on certain tests like blood cultures and stuff like that. So
When were the alcohol swabs removed from the emergency department?
moist
it was before my
towelette
time.
is apparently
Fair to
a
say prior to January 29th, 2022?
Correct.
What is a phlebotomist and what do they do?
So a phlebotomist is a healthcare professional who specializes in drawing blood. So they're the ones who are trained, competent, and know what to do when they draw a patient's blood.
What kind of training do phlebotomists receive at Good Samaritan?
We try to hire phlebotomists who have been trained. It's just easier. So they can have a high school background, but if we train on site, they just need to be trained on the proper protocol, proper procedures, and demonstrate competency.
Is there any sort of proficiency testing related to phlebotomists at Good Samaritan?
There's no proficiency testing for phlebotomists, but there's competency assessments. So
Fair enough.
With phlebotomists or any laboratory technician or even pathologists, there are strict guidelines for competency. We have to always make sure people know what they're doing, and it's a CLIA or a federal government regulation or requirement. So when anybody first starts in a hospital, the requirements are, one, initial training. You can't let anybody come in on their own, without not knowing what they're doing. So we have to document that they have the initial training and they're competent. And then the law says 6 months from that, we do another competency assessment where we look at 6 elements of competency defined by CLIA. And 6 months from that, 1 year from the start date, is another competency. And then after that, it's annual thereafter. And that goes for phlebotomists, and that goes for any laboratory technician.
Doctor, once the blood is drawn by the phlebotomist, what happens then?
So the phlebotomist will draw it at the time. They need to have the specimens labeled in the patient's room because you don't want the phlebotomist to mislabel. So everything gets labeled at the patient's bedside with an initial and with a phlebotomist initial and date and time. That blood test will then be sent to the lab. In this case, the blood was drawn in the emergency room, so it gets packaged into a plastic bag and sent in a pneumatic tube
patient
up to
info on
the
it.
laboratory.
Is your
Once it's
pneumatic
sent to the
tube
laboratory,
cool?
what happens with the sample from
Does
there?
it just go?
Once we receive
Questions?
it, it's called receiving the specimen. There will be a technician who then goes into the computer, enters the phlebotomist's name from the tube into the computer system, enters the...
Rachel asked a great question in the chat. Rachel said, why are they not using a phlebotomist as an expert here? This is the head of pathology who is going to be testifying about the policies and procedures. You can't question the phlebotomist at the hospital about the policies and procedures because generally it is above their pay grade. And so the main issue here is not that the blood was drawn, it's the how the blood is drawn, for what purpose, what the lab policies and procedures are. So that's why they're going through this with the head of pathology who runs the lab at the hospital, because they need to go through the policies and procedures. And this is the person in charge of those policies and procedures. And they have the breakdown for how it was done with the patient, but it's not a question that blood was drawn. Blood was drawn. Whether this lab is the proper kind of lab to do the blood draw is what the defense is going to bring up, and what the prosecution is going to bring up is lab was drawn properly, and this is what was done. But this lab, the lab work done here is for medical purposes, not for investigative purposes, and that's where the difference is. And so that's part of the breakdown that we're going to see. Again, I don't know if it's going to matter much in this trial, with all things considered.
Time, and the technologist will look and see what was ordered, and then do the appropriate next step based on what was ordered.
And in a case in which alcohol is one of the items that are ordered, what is the next step as far as the testing goes?
So the next step with alcohol testing, we use a specific tube, so the phlebotomist would know what tube to use. It would be a light green tube that has lithium heparin in it as an anticoagulant. We don't want the blood to clot, so that's why we use an anticoagulant. So the first step when testing for alcohol is that the test is designed to be performed on serum or plasma. And to get that, the next step would be to centrifuge the blood. The centrifuge is a machine that spins the blood rapidly. We spin it at around 3,300 RPMs, which is pretty fast, rotations per minute. And the reason why we spin it, because centrifugation will allow it to separate the blood components based on the density. So heavier stuff like the red blood cells will go to the bottom, and the lighter stuff like the watery component of the blood will go to the top, and some of the white cells go into the middle. But for alcohol testing, we are targeting the top part of the blood component, which would be plasma.
And then once it goes through the centrifuge process, what happens then?
So once it's centrifuged, we have the separation of the blood components. We have the plasma ready to be tested, so that technologist will walk the specimen over. It's probably 10 feet from there, and put it onto our Roche Cobas machine. That's our machine that performs our chemistries as well as alcohol testing. It goes onto a machine. All the testing is basically inside of a black box. And the label present on the blood tube will dictate what the Roche machine will test. So based on the barcode label, once it's on our machine, it knows what test to do, and it will perform an alcohol test.
And Doctor, for our stenographer, do you know how to spell that Roche Cobas machine that you were just referencing?
So R-O-C-H-E, Roche, and Cobas, C-O-B-A-S.
Thank you, sir. May I approach on?
Yes.
SC Hunter 717 asked in the chat, in the first trial, did they ever determine when Karen Reed had her last drink? I don't think it was established to a certainty,
look at that and look up here.
because there was no information about whether she had more drinks when she got back to One Meadows. I ultimately don't think it was a huge issue for the jury after seeing the video, but no, it was not. It was circumstantial, and the jury could determine that she had her last drink, because the other testimony was she went back to One Meadows and went to sleep, and there was nothing else. But there's an argument that you don't know what happened from the time that she left the waterfall to the time that she went back to 34 Fairview. They have more information in this case because they have Karen Reed's own words that they have now used. So they're going to go through this process, but because they have the clips of Karen talking about drinking and driving, I don't think the discrepancies in the blood serum testing and the retrograde extrapolation are going to be a huge issue in this trial. This time. They weren't, for the jury, they weren't a huge issue last time either, it seems, but I think the drinking and driving has been established.
Do you recognize those records, sir?
Yes.
And what do you recognize those to be?
These are the medical records of Karen Reed.
And sir, is there an indication within those records as far as the date of treatment for Ms. Reed?
Yes, there's a bunch of dates in here.
Okay.
As far as the treatment is concerned, sir?
There's a bunch of dates in
yes.
here.
And what is the date of treatment?
Oh,
He just said there's a bunch of dates.
1/9/22.
One,
Sorry, is that 29/22?
Me.
That's what it says on this.
Sir, you know what date we're talking? What?
At mid-date, it says 1/29/22.
I mean, that's fair. I would also want readers.
Thank you, sir. That's fine. Doctor, if I could direct your attention further into the document.
Oh,
to the
I also
previously
take my
tabbed
glasses
portion,
off to
Do
look.
you see any indication in there as far as
Minor distance.
a result for alcohol testing?
Yeah, mine are distance glasses. I have to take them off for my phone. It's so annoying. Emily, do you maybe need bifocals? Probably, but they make me motion sick. So
Yes, I do.
I also take my
And
glasses off to see
with
better.
respect to that result, have you reviewed these records prior to today?
Yes, I did.
And if you could explain to the jury sort of the timeline from this blood sample as far as, let's start with first when it was ordered.
So when it was ordered, it was 9:03 in the morning.
And when was it taken, sir?
The blood test was taken 5 minutes later, so 9:08.
And then what happened, or what is the next time that something of any significance happened with it?
5 minutes from that, 9:13, we received it, and 9:53 in the morning, the result was entered into the computer. So
My
it was
brain
ordered
is
at 9:03,
spicy.
and I believe it was
Lovable swamp witch.
9:53. The results were in the computer.
My brain
And
is
may I
spicy.
approach again, Your Honor?
Bifocals make me motion sick. So,
I'm about to seek to introduce
Jay
the
Ray
witness.
said, can we zoom yet? No,
Any
we need the
objections?
foundation. We're just gonna get through the foundation.
Yes.
What's important is how the blood was drawn, what type of blood alcohol testing they do, which is serum or plasma
Doctor, what was the
testing,
result of the
that Karen
testing for
Reed's-
alcohol in the defendant's blood?
and that
when it
Karen
was-
Reed's blood was tested. That's what the important part is. So I'm going to slow this down real quick because they're getting to what was Karen Reed's blood alcohol as they tested it by serum.
taken shortly after 9 a.m. on January 29th.
93 milligrams per deciliter.
Thanks. Nothing further, Your Honor.
Okay. Ms. Little?
And now we're on to cross with Attorney Little. I like the change up of attorneys
Good
for
afternoon,
this
Dr.
witness. It's a
Fowler.
nice change of
good
pace.
afternoon.
The Good Samaritan lab is a clinical lab, not a forensic lab. Is that right?
Correct.
And hospitals are not in the legal business of calculating an individual's blood alcohol concentration. Is that right?
I would say 99.
I'm just gonna warn the chat. The 93 milliliters per deciliters does not have context for the jury yet. It is not a direct conversion, so you can't just put a point in front of there. It is not a direct conversion for BAC. There is more conversion that needs to happen. So that concentration in blood serum does not directly correspond to BAC without conversion. So you can't just convert it with it. No, you can't just say, oh, that equals this without going through the conversion. So for any of you thinking, holy shit, that sounds like a lot. We're not there yet. We're not there yet for the conversion. Do not worry. Do not worry. We're not there yet.
0.9% of the time, we are not in the legal business. We are testing alcohol for the diagnosis of alcohol intoxication. But occasionally, a case may come, very rare, to a hospital, and it ends up being a legal case. It's not common. I think uncommon.
And you'd agree that there are differences between screening tests that are conducted at hospitals and forensic tests that are conducted by law enforcement, right?
Yes.
The purpose of testing in a clinical setting is to assist in the diagnosis and treatment of a patient, right?
Correct.
And physicians need to analyze blood quickly. They need to get the results so they can see what's in a patient's system and then effectively and efficiently treat that patient, right?
Correct.
Whereas in a forensic setting, tests for blood alcohol concentration are designed to produce results that are reliable and credible for use in court. Correct?
Correct.
You
Right.
testified earlier
Just
today that
answer
your
the
lab is
questions on cross.
accredited
It's
by
so much easier.
CAP, which is the College of American Pathologists. Do you recall that testimony?
Yes, I do.
But CAP is a clinical laboratory accreditation, not a forensic accreditation, right?
We don't have the forensic accreditation for
So
Good
that's a
Samaritan.
yes. So that's just a yes.
In fact, Good Samaritan
Correct.
has never been investigated or accredited by any forensic accreditation team.
Correct, or a
To
hospital.
ensure that you perform all of your tests with the integrity necessary to support results in court, right?
We've never been, we've never had the forensic accreditation.
Right,
but
you're not
we
a
have
forensic lab.
Very good good quality lab results, which I could go into.
Sir, she's not attacking your lab. There's nothing
further.
wrong with your lab. Your lab's great. Your lab's beautiful. Your lab is not under attack. Your lab is fine. But you're a clinical lab, not a forensic lab. It's just different. It's not bad. It frustrates me so much when witnesses, especially neutral witnesses, and this is a neutral witness, take it personally. There's no judgment on it. There's no value of one's better than the other. I don't know if within the scientific community, people are just like, you know, oh, well, we're clinical. Oh, well, we're forensic. They're just different purposes. It doesn't mean your lab's bad. It's literally neutral. You're a lab at a hospital. Your job is to treat patients. It makes me nuts. He's just like, but we're great. No one's saying the Good Samaritan lab's not great. It's just different.
But you've never been accredited by a forensic accreditation team.
Chris McCurtis said, don't be dissing my lab.
And
exactly.
the lab at Good Samaritan has never been accredited by the ANSI, which is the National Accreditation Board known as ANAB. Are you familiar with that organization?
No.
I'm ready for
that ANAB is the.
I'm ready for him to be like, no, why would we? We're a clinical lab. When I say everything in this case is weird, it's because everything in this case is weird. Generally, if there is a DUI investigation ongoing, and I can only speak from my experience in California, not from Massachusetts, but generally, law enforcement can get a warrant and request a blood draw. The hospital does the draw, and then it goes to a different lab to be tested. It goes to the forensic lab or the state police lab or whoever's lab that they use for it, because they do a different type of testing. That's it. That's it.
Forensic accreditation body that in the United States that ensures that laboratories' procedures meet the minimum standards necessary to ensure results are reliable and credible for use in court.
Sustained.
It was compound.
Now, the most reliable method of forensic ethanol testing is called headspace gas chromatography, or HSGC. Are you familiar with that process?
Yes.
And HSGC is the method that's used by forensic labs to test for blood alcohol content, right?
Correct.
And that's because forensic tests require the testing of whole blood for the presence of alcohol, right?
Correct.
Can you briefly, just for the jury, describe
that's
sort of the
different.
difference between a whole blood test and a serum test?
Sure. So whole blood, to put it simply, when you have your blood drawn, you see the fluid coming out, all red. That's whole blood. We don't do anything to it. We don't spin it down. We don't centrifuge it. That is whole blood.
Blood in a vial.
That is the specimen of choice for forensic blood ethanol testing. Hospitals, on the other hand, our methodology, which is just as good as the forensic headspace gas chromatography, is based on looking at the serum or the plasma. So we don't. That's what I went when I explained that we need to centrifuge it, take the liquid portion off the top. So in the hospital, we test it on the serum or the plasma. Now, did you ask me the difference? You want me to go into the difference?
That's enough, Doctor. Thank you. I'll ask some additional questions to kind of clarify.
No, that's enough. We're good.
And
He
in a
does. He
forensic
sounds
lab,
mad.
they actually require the testing of whole blood, correct?
Correct.
And HSGC directly measures ethanol in the blood.
Correct.
And this method is designed to be accurate and reliable for forensic purposes for use in legal proceedings, correct?
Correct.
But the testing in this case was performed using the hospital's clinical chemistry machine instead of a forensically defensible method like HSGC.
It's so argumentative. It's such an argumentative question. And it's not argumentative in the legal sense, doesn't mean like they are hissing at one another, though it can feel that way. The argumentative question means that there's some type of argumentation in the question. I think this is a perfect example. The forensically defensible method, that's the argumentation in there, saying you used your chemistry set like one of the opening scenes of Twilight, not the forensically defensible method of HSGC. So it's the argument and the argumentation in there is that bit. Hopefully that makes sense when I say that the question's argumentative. But you can also tell that the question's argumentative when you look at the witness's face and he's just when you guys use your like chemistry kit, he's like, ma'am, we're a hospital. We're not just like testing blood type at a high school. What? He's so mad. It's just, that's funny. I don't know if it'll draw an objection, but it's a really good example of where questions can be argumentative without it being, I guess, aggressive. Does that make sense? What a great example of a question, Miss Little. Thank you.
Right?
Correct.
And that clinical chemistry machine performs what you just testified to, a serum test, right?
Serum or plasma.
Serum or plasma. And hospitals use serum or plasma testing because it's actually quicker and more efficient than HSGC, right?
Yes, it's less labor intensive. It's easy to automate. But at the same time, very, very good and very accurate.
But serum testing does not actually measure alcohol directly. It instead measures the presence of what's called NADH, right? Yes, I'll repeat that.
That was the court reporter.
My fault. Serum testing does not actually measure alcohol directly. Instead, it measures the presence of NADH. Is that right?
Almost.
Well,
Is that
NADH
right?
is a byproduct of alcohol, right?
Correct. I can go into the testing how methodology that we use to explain it if you want me to.
Well, serum testing measures the presence of NADH, correct?
It measures the rate of change of NADH production, so it doesn't actually look at just NADH, and it measures the rate of production, and I can go into more detail on that.
You can do that on redirect. That's not her
alcohol
point.
testing in the lab is correct.
I'll ask you some additional questions
sure.
about NADH, and we'll get there.
Yeah.
So you can do this now, but let the doctor answer his question fully next question, okay? And the following question.
I mean, he wants to explain more.
Doctor, the higher the
but
NADH in a patient's
that can
system,
be
the
for
higher the
redirect.
serum test result, correct?
That may not be correct, no. It's the rate of change of NADH production based on our methodology. I can go into that. So our test system is a little bit different than the forensic testing system, but it's also very good and very accurate, and almost when we compare our methodology to the Headspace, we get the exact same results, and when we compare and with peer laboratory comparisons. But what we do is and I think the jury needs to know this. Maybe some of you might understand the chemistry behind it, but we do. We take the patient's sample, and it's based on we add, because when there's alcohol in the specimen, we add actually in the test system alcohol dehydrogenase. It's the same enzyme that's in the patient's body. In addition, we add a surplus of NAD to it. NAD is similar to NADH. They get converted back and forth. So when we put it on our test system, it's alcohol dehydrogenase is in there, and what happens is when there's alcohol, it combines with NAD that we add to it. It creates NADH. And then in our machine, there's a spectrophotometer, which can monitor the rate of NADH production over baseline. And we use, there's a something that measures, a photometer that measures the NADH production. It looks at light in this physics and looks at 340 nanometers. And it's pretty accurate. It will monitor, it will tell you, it will tell the system how much NADH is produced, and that amount is directly proportional to the alcohol in the patient's sample. So it doesn't
test alcohol.
Very, very accurate test.
So it doesn't test
but
alcohol.
there are some limitations that I can go into.
So wait for another question.
The judge is like, just wait.
Yes,
It's
so
very
serum
accurate with some
testing can be
limitations.
subject to errors, right? And there are limitations.
There are some limitations that I can explain, just like head-space gas chromatography
Sir,
may have some limitations too.
Everything's going to have some limitations.
But I can go into them.
Yeah, next question.
I understand you want to defend the lab. I get it.
Of
the serum testing.
Okay. So the serum test, as with many tests in the laboratory, different things can interfere with our laboratory tests. And the three most common ones, which are unlikely to affect ethanol testing, is we abbreviated HIL. We want to look at those three things. One is hemolysis, which is H, and the other one is icterus, which is high bilirubin, and the third is L for lipids. High lipids will interfere with alcohol testing or with any testing based on that same methodology. Our machine, the Rose-Kobash machine, and all the machines out in the market today are very sophisticated. If we have elevated levels of any H or I or L, it will flag it and raise the potential for a problem. The next thing on the list is that our alcohol testing is not absolutely specific for ethanol. There are two possible other alcohols that can cross-react. One is propanol and butanol. But then it goes clinical history. Did the patient ingest those two alcohols?
He is very good at explaining it. It's probably too in depth for the jury. He and the lawyers are having a moment. The jury's like, we've already heard clips of her talking about drinking and driving. It's very important to all of the attorneys. How important this is to the jury, we'll see. I also appreciate that he's like, I'm not going to leave a misimpression that our testing is not accurate. I completely get it, but it gets very deep into the weeds of the explanation. How much does it matter after what the jury's already heard? Probably not much to them. They're like, okay, we got it. Tell us what the BAC is. The defense is doing their job in pointing out where there are differences. It's not going to matter that much to the jury.
There's some unusual
it really
hematologic malignancies like Waldenstrom's macroglobulinemia that can interfere. So it's always have to correlate with the clinical situation. The next one, sometimes there can be patients who make endogenous make their own alcohol. So very rarely, some patients may truly have a positive result. That could be from our test or Headspace. They make their own, so we have to rule that out. That's a rare condition. And the next one is one that's in the literature, which is LDH and lactic acid. If a patient has a markedly elevated LDH or lactic acid,
are any of these things present here?
An enzyme.
No.
And the other one is an acid. That can cause false positives. Now,
if I can stop you there, Doctor. I think those were the four that you identified, the four limitations: the lactic acid, the
Yeah.
If I
Are any
could
of
ask
those
you a
things-
few-
ask your next question.
If I could ask you a few more questions.
Are any of those
about
things present
LDH
here?
and
No.
lactic acid.
Sure.
You're aware,
Great.
Dr. Fowler, of the medical literature establishing that the presence of LDH and lactic acid can lead to falsely elevated serum readings, correct?
Correct.
And that's because lactic acid, or LDH, actually forms NADH.
Lactic acid,
It's like, well, not exactly.
I'll have to go into a little bit of chemistry.
Okay, we're already
Lactic
here.
acid and LDH, lactate dehydrogenase, they both act on each other. And LDH and lactic acid needs NAD plus to break it down. So in theory, when you're testing a serum, a plasma for blood alcohol, if there's extra LDH or high levels of LDH, high levels of lactic acid, you add it to the test system, and then Roche throws in, or Siemens throws in the NAD, it will form NADH. That was first documented, I think, back in the older versions of these
Chad, he was talking about the
ethanol
lab
testings
company
back in
that
the
makes
1990s
equipment.
when they stumbled on, they were looking for biomarkers or reasons in kids with SIDS, little babies, and they found that two of these babies had a positive alcohol. But
Doctor, if I could just ask the next question, if that's okay.
Sorry.
He's like, no,
So in other
actually.
words, NADH,
He's like, no, actually, the history of this is really interesting. And so to understand why there might be this correlation here goes back to studies in the 90s so that you understand why we are adding this information in because of the studies that we did. So he is explaining the history of why the lab tests do what they do. And Miss Little's like, yeah, okay, but you're not a forensic lab, right? You're not a forensic lab though, right?
studies have found can actually
That's
be
her
formed
point.
by certain biomechanical processes
I know, I want the rest
other
of his
than the
answer
presence
now.
of alcohol, right?
Yes.
Are you aware that the National Institute of Health has found that liver diseases, kidney diseases, muscle injury, trauma, and even anemia are some of the health conditions that can lead to a rise in serum LDH levels?
Yes.
Are you aware that Ms. Reed was severely anemic in January of 2022?
Sustained.
Are you aware that the medical literature has also found that patients suffering from multiple sclerosis have a twofold increase in NADH levels as compared to controls?
I'm going to allow that.
I haven't read anything specifically related to the NADH level, but but I want to go back to the point where our laboratory, our testing is not based. It's not testing.
Let him finish his answer.
It's not. It's the rate of change of NADH. So if somebody has NADH on board, I believe it's not going to affect the result. It's the rate of change, and it basically, you know, back to the anemia. I haven't read or heard of that.
That was stricken. That was
Okay.
not allowed.
It all goes back to the lactic acid and the LDH. The NADH doesn't matter. So looking at multiple sclerosis patients, they can have elevated LDH and lactic acid, but it's not to the extent that it can interfere with the alcohol levels. There was a study maybe 7-10 years ago.
Your Honor, there's no question pending.
Yes,
you
there
asked him
was.
about a study, if he was
You
aware
asked
of the
him if he was
studies.
aware.
That's a yes or no question.
You said, are you aware about patients with MS a twofold level of NADH? And he's like, it's yes, it's phrased in a yes, no way, but this judge allows all of the witnesses to explain. So he's going to say, well, yes, I'm aware of studies. This is why it doesn't matter. Here is the explanation. And the explanation for him is the starting amount of NADH in the blood isn't relevant to their test because their test tracks the change, not the static.
And he's
All right, Doctor, we're going to hold that there for you and ask the next question.
Doctor, have you reviewed the August 21st, 2013 peer-reviewed article entitled Serum NAD through Disease Course in Multiple Sclerosis, which was sponsored by the Center of Healthy Brain Aging by the University of New South Wales? Which,
Do that again and slow down, please.
sure. Doctor, have you reviewed the August 21st, 2013 peer-reviewed article entitled Serum NAD Levels through Disease Course in Multiple Sclerosis, which was sponsored by the Center for Healthy Brain Aging by the School of Psychiatry at the University of New South Wales in Sydney, Australia, which specifically found that patients suffering from multiple sclerosis have a twofold increase in NADH levels as compared to controls?
No, what's your objection?
I'll strike the part of what the article held. Is he aware of the
that's
article?
fair.
No, I'm not, to be honest, no.
Well, yes, please be honest. You're testifying.
Dr. Fowler, did you consider Ms. Reed's anemia and multiple sclerosis condition when you conducted the alcohol test on January 29th, 2022?
No, we don't, no.
And again,
There's a
serum
yes,
tests like
no.
the ones conducted in this case don't test for ethanol. They only test for NADH, right?
We test for the rate of change of NADH production.
And Dr. you
That's a
did a
fair
number of other
explanation.
tests on Ms. Reed on January 29th, 2022. You tested for additional drugs, not just alcohol, correct?
Correct,
And all of those results were negative.
correct.
Thank you. No further questions.
Okay.
It's a fair cross. Again, there are fair points to be made. For the jury, is this going to matter much? I don't know. I think that Karen Reed's
Doctor,
own
are you
statements
aware,
will
I know your
overcome
lab
that.
at Good Samaritan did not do this process, but are you aware through your training and experience of any sort of mathematical conversion that can be done from a serum reading in milligram per deciliter to
Why
a
are
blood
you
alcohol
asking this witness
concentration in whole
that?
blood?
It's outside the scope.
I'm going to allow it. The door was open.
Go ahead, sir.
Yes, I am aware, yep.
And please describe what you're aware of with reference to that.
Well, with blood alcohol concentrates goes to, when it's in your blood, it goes more to the watery components of your blood. So when I described the process earlier, whole blood is before we spin it. And when we test the plasma, which is specifically testing the watery component. Now, people have done studies like how much percentage of water is a serum versus whole blood. Basically, to put it simple, there's a higher percentage of water in the serum versus whole blood. So a hospital result will always be a little bit higher than a test on whole blood. It can be, I think the ratio, the conversion factor is anywhere from 1.1 to 1.18. It's always could be 18% or 11% higher in serum versus whole blood. But we don't do it. That's what I read. I will defer that to the experts.
Now, Doctor, you were referencing in your cross-examination about a study that you were aware
Again,
of. About
it's an interesting question. And the question was, okay, so in the testing you're doing, and the court said, no, the door was open because Attorney Little was asking about the difference between the whole blood testing and the serum testing. And he said, look, we don't do that conversion here. We don't convert it. But I am aware that because we are only testing this component of the blood, that there can be an 18 to 11% difference from the result of serum testing versus the result of a whole blood testing. But we do not do those conversions. They are not a forensic lab. They are using this for medical purposes. So the things that they are evaluating for are for treatments, interactions, etc., not for legal limits in driving. I think it's fair, and I wonder if Ms. Little was unsure what he was going to say, but I think it's fair of him to clarify, hey, our tests, when they are converted, will be 11 to 18% higher. But he's not the one doing that conversion. A different witness will do that.
About 10 years ago or so regarding MS and alcohol testing, is that correct?
It was more on MS, looking at the results of lactic acid and LDH to see how high the levels of lactic acid can go in a group of multiple sclerosis patients. When reviewing that, we found that the range went from some normal range, 16% of the multiple sclerosis patients had normal lactic acids, but the remainder had elevated levels. But those levels were not anywhere near the required levels to produce a false positive. Our package inserts and for the Roche testing system, the Roche has, it's an FDA-approved test, and they have to do in-depth, detailed testing before they allow any hospital to do a test. And they have listed, levels of lactic acid beyond which the test would not be reliable. But
And
the
that
results,
makes sense in the
based on
medical
this
context.
study of 600 multiple sclerosis patients, 2 big centers in Italy and 1 in the Netherlands, show that the highest level of lactic acid in the MS patients did not achieve, didn't get close. Usually patients with MS that are asymptomatic can have normal or low normal levels, or slightly elevated. It was the ones that had more symptoms that had elevated levels up to, I think the highest was 6.5 millimoles per deciliter, which is not high enough to interfere with our result.
Now, with respect to the lab at Good Samaritan Medical Center.
I muted myself. There is a point. Peggy asked, so how can we trust the hospital BAC levels for driving if the numbers could be? That's not what he's saying. He is saying there's a reason it needs to be converted because there is a baseline difference. And that's why there will be another witness that will convert it. He is saying this is our base level result. There is another expert that is going to talk about the basis for that conversion. So he's saying, I am not an expert in this. This is my understanding. This is how we do it because we are doing it for medical purposes. But that is part of why there is a conversion process, because the testing is different. So that is why you can't just take the number he is giving and correlate it to a legal BAC because it's different. Hopefully that makes sense.
The interference that you were speaking about earlier on cross-examination, what would happen if any of those types of interference were to occur during the course of the testing?
Objection.
No, I'll allow it.
The 3 main ones, which I detailed earlier, is the hemolysis, icterus, and lipemia. Our machines are sophisticated. It will detect it and say, it will flag it and say, please do not result it, or we'll have a disclaimer saying, interpret this result with caution. The results may not be accurate. It hardly ever happens with alcohol testing. But if it did, we would get a result like that, and we probably wouldn't report it.
And from your review of the defendant's medical records, specifically her testing from January 29th, did you notice any interference or any reports like that in her record?
No.
Now, the testing that you're doing at Good Samaritan is in relation to patients such as that might have cancer or heart disease or something like that, correct?
Correct.
Now, you were talking or started to speak on cross-examination about the good quality lab results that you have from your lab, and you wanted to go into that further. Could you please expound upon that for the jury now?
we have, you mentioned proficiency testing before. So all hospital laboratories accredited by the CAP or have to participate in proficiency testing. What that means is that every 3 times a year, and they give us 5 unknown samples. And we have to test it, report it back to CAP, which also reports back to the government. And we have to basically get the correct answers. And with alcohol testing, it's probably one of the best tests in the laboratory. Always have right on the money results. But at the same time,
the results are for a
we're
different
also
purpose,
able
is
to
the
look
question.
at results of all the other labs that participated in this proficiency testing. So we can look at different methods. We can look at labs that had the same method as us to see how we're doing. And usually with this proficiency testing, we have 3,000 labs across the nation that have the same methodology as us, so we can compare to them. And also, interestingly, we can see the labs that are using headspace gas chromatography. And out of interest, we can see how do we compare, and we have pretty exactly the same results on these proficiency testings. We also look at some statistics as well, not going into them, but we can look at some stats like standard deviations and SDs. And actually, the hospitals with enzymatic testing have slightly better stats with that compared to Headspace. Pretty close, but a little bit better.
And doctor, from your review of the defendant's medical records and the blood testing in this case, was that done in conformity with the policies and protocols at Good Samaritan?
We have policies in place to be followed, and there's no reason not
So is
to
that a yes?
think that somebody didn't follow policy.
So yes? So yes?
Thank you, sir.
So yes.
Anything else, Ms.
So
Little?
yes.
No questions.
All right,
Okay,
Doctor,
good.
you are all set, sir.
Thank you.
For those of you asking, there is very much a legal reason why this witness matters. The legal reason this witness matters and whether it will matter to the jury are 2 very different things. This is foundational information regarding Karen Reed's blood draw that was taken at the hospital when she was Section 12. So we are laying the foundation for the lab processes and procedures and the way that the lab not only takes blood, but the kind of blood testing they use. The forensic labs use a different type of testing than the medical labs. In this case, they were testing Karen Reed's blood pursuant to the Section 12, not pursuant to a warrant as a part of an investigation. So they didn't draw blood and then send it out to a lab to do the forensic testing. They drew blood and tested it at the hospital because they were doing their protocols and procedures subject to or because of her Section 12. When they started investigating this case, when if ever, down the road in the investigation of this case, they went back to get, which the jury doesn't know at this point, they went back to get those results and then do the mathematical conversion. They didn't go and get, because you can't, more blood from Karen Reed to send out to be forensically tested. If you have a normal process and procedure, there would have been a warrant and then the blood would have gone out. That ship had sailed by the time they come back around to charge Karen Reed in this case. So they took the medical chart results, sent them to another expert to say, these were the medical lab results. Can this be converted to a range of blood alcohol? So that is what we're getting into with these witnesses. Hopefully that makes sense. Let's get to the next witness, because we are done with that.
Do you have another witness, Mr. Brennan?
I do.
Okay.
The Commonwealth calls Jason Becker.
So witness 10. from April 25th, 2025, day 4. But for the jury, they have seen Karen Reed's statements about drinking and driving. They had the jury view this morning, and they're sitting there going, okay, here we are.
Do you solemnly swear that the testimony you shall give to the court and the jury in the matter now pending shall be the truth, the whole truth, and nothing but the truth, so help you God? Good afternoon, sir. All right, Mr. Brennan.
Thank you, Your Honor. Good afternoon, sir.
Good afternoon.
Could you please introduce yourself to the jury?
My name is Jason Becker.
How old are you?
I am 36 years old.
Do you live in the area?
I do. I live.
Why do we ask the witnesses their age? Just why do they ask the witnesses their age? Just why are we? I understand why he does it with some of the paramedics, especially if they look maybe younger than they are, to say, no, they have experience, but you can just ask how long you've done your job. Amy said, is Massachusetts zero tolerance for DUI? Amy, this is not directed at you, and I am trying to read this question genuinely, but I have watched so much of this case. I think we're at the opposite of that. And that is not me snarking at the questioner, because this is a very fair question. I think whatever the opposite of that is where we're at. Because the amount of drinking and driving in this case, including by law enforcement, is just staggering. So, no, it seems that they have a fairly high tolerance for drinking and driving, but we're not there yet. The jury isn't there yet. The threshold and the tolerance seems to be different because it is so normalized. And it is just so normalized, especially within this particular group. And more will come out about it. It will continue to get worse. The amount of drinking and driving will continue to get worse. So I appreciate, Amy, that you asked the question. And I hope it didn't come across that I was snarking at you. The amount of drinking and driving in this case by so many individuals it just blows my mind. It just blows my mind. It's really wild to me. So Jesse said, oh, wait, does that mean we're not going to get the same BAC guy this trial? I liked him. I liked him too. There was a pretrial motion that he was unavailable, and I believe this is the lab supervisor. That happens commonly in trials, especially with scientific evidence. Oftentimes in labs, I think it's probably required in most labs, but it's outside of my area of expertise. You will have the person running the test, and then you will have somebody double checking and validating those tests. If a witness is unavailable, you can have the supervisor come in to testify to it. They made a motion about it. There was no objection. So we're going to continue on. We'll get to more questions. Harpo Hootis woman. But for a DUI, the hospital isn't the one processing the test. In this case, they were, because they weren't investigating Karen Reed for a DUI at that time. They took the blood because of the subject 12 and are using the results for other purposes later. There were motions about this really early on in the case, and the prosecution is using this. So Reximoto said Arizona has zero tolerance for DUI. Does Arizona still put DUI offenders up on like billboards on the freeway and stuff? I remember they used to do that. They would just put DUI offenders up on billboards. So if you're driving to work, you're like, wait, what? Yeah. There was a whole like public shaming campaign that happened in Arizona a while back. I don't know if they still do that.
I live in Canton.
Let's continue.
Tell us a little bit about your education.
My education, high school and college UMass. And I went to...
What was that? What did you say?
Tell us a little bit about your education.
What? Where?
My education, high school and college UMass.
Go
and
Minutemen!
I went to EMT school a little over 10 years ago and paramedic school.
I played water polo at UMass. I have very warm feelings for UMass. But I mean, I'm assuming Gloria B, this is fair. Gloria B in the chat said, which UMass? I feel like if he went to like UMass Dartmouth or UMass Lowell, he would say UMass Dartmouth, UMass Lowell. I feel like it's UMass. Like, I feel like it has to be Amherst because that's like Amherst is UMass and everything else has a name. So that's why I had to give context. Like UMass with nothing else is Amherst, right? I loved UMass. I loved UMass.
Tell me a little bit about EMT school. How old were you when you started EMT school?
When I started EMT school, roughly 21 years old.
Why did you decide to go to EMT school?
I wanted to save some lives.
Tell us a little bit about
sir.
EMT school. What did it require?
We're laughing about college, not you. Why did you go to EMT school? I wanted to save some lives. Sir, we appreciate you. Thank you for the work that you do. I am laughing at chat, not at you. That is a very noble reason to go to EMT school. But also, I got sidetracked about UMass Amherst. Sorry.
EMT school is a couple months of classroom stuff, and then you do some ride time on the ambulance. Paramedic school is a little different. It's a little extended.
Paramedic school's a lot different.
2 years worth of training. You're doing hospital, ER time, and ambulance time also.
How long did you serve as an EMT before you went to paramedic school?
I worked as an EMT for approximately 5 years.
Can you estimate how many dozens or hundreds of calls you were on during that time?
Hundreds.
Why did you decide then to go get paramedic training?
I wanted to be on the fire department, and it was a prerequisite.
Did you complete paramedic schools?
Look, the more I've learned about fire department retirements, the more I also want to go to the fire department. I didn't make good life choices, though, so here we are.
Successfully?
I did.
Were you still working as an EMT at the time?
I was.
And inevitably, did you seek to have a different job? Did you try to be a firefighter?
I wanted to be a firefighter, correct.
Were you successful in doing that?
I was.
Tell us a little bit about that, sir.
It's awesome.
The Canton Fire Department.
I learned how to
the Canton Fire
cook.
Department, and they send you to the fire.
We have sleepovers.
Fire Academy.
Bell
you
goes
train to be a
off.
firefighter.
Out the door.
So you had EMT training, paramedic training, and then firefighter training.
That's correct.
On the Canton Police Department, did you serve dual roles as a paramedic and as a firefighter?
Fire department?
Yes.
Yes, sir. Yes, sir. Firefighter and as a paramedic.
Also, this witness has nothing to do with the last witness. This is another Canton fire medic. So Canton fire medic is where we're at. When will we get to the other lab experts? I don't know. I imagine the Commonwealth is going to fill them in or when they have time, but another paramedic.
You served as a firefighter and a paramedic.
Correct.
In the Canton Fire Department, does it have more than one station?
There's two.
Is there one station that's larger or smaller than the other?
Station 1 is the headquarters, which is
Brendan,
larger.
why are we being
Have
a
you ever
size
spent
queen
time
about
at
the
Station
stations?
1 as a firefighter or a paramedic?
I have. We rotate through both stations.
I want you to take us back to January 29th, 2022. Were you working that evening?
I was.
What station were you assigned to?
They do. They get
Canton Station 2.
Canton
They get
Fire
to drive the
Station
big
2?
red trucks.
Correct.
They
And
get
that's
to
the smaller of the two stations.
they get to
It
do
is.
charity work.
Were
They're
you
in
working
calendars.
with anybody at Fire Station 2 that night?
My ambulance partner at the time was firefighter Dan Whitley.
Was
There
there
we go.
anybody else who was working at Fire Station 2 in addition to you and Dan Whitley?
Correct. There was an engine
Now
company
we know
with three
why
guys
he's
on
here
it.
today. He was
Three
Whitley's
people
partner.
were assigned to the.
The engine, correct.
Were you and Dan Whitley assigned as partners for the day, the week?
Correct. Yes, we were.
Which was it, the day or the week, sir?
The week.
So for the entire week, you're partners with a person, and does that rotate on other assignments?
It does. It rotates.
So on this particular week, you were assigned as partners with Dan Whitley.
I was.
Who's your favorite
What were
person
your
to be
roles
partnered
between
with?
the two of you?
I have questions.
At the time, he was my preceptor. I was a new paramedic at the time. So I was more or less the lead tech on all the calls as part of my training. And Dan's been a paramedic for a long time. So he was there to teach me.
So would Dan Whitley be the lead on the call, and he would help you?
I would be the lead.
You would be the lead.
Correct.
Did you get a call that early morning hours of January 29, 2022?
We did.
What was the call assigned for?
It was a call for Section 12 psych eval.
Very briefly, can you tell us what a Section 12 is?
Sure. It's a transportation order filled out by police, doctor, basically for us on the ambulance that we have to take the patient, whether voluntarily or involuntarily, because they're a threat to themselves or someone else.
When you received the call for a Section 12, were you aware that there were other calls that Fire Station 1 had responded to that morning?
We were aware. You can hear the calls going out each station.
Were you or Dan Whitley any part of that earlier call that Fire Station 1 responded to before you got the call for the Section 12?
We were not.
So your efforts were after?
We were after, correct.
After you got the call to respond to a Section 12, did you head towards Fairview Road?
We did.
Tell us a little bit about the trip to Fairview Road.
It was a little extended because of the weather conditions at the time. Snowing heavily, windy, low visibility.
Okay. How long did it take to get from Fire Station 2 to Fairview Road?
Approximately 8 to 10 minutes.
Who drove?
Firefighter Whitley.
Now, on the way to Fairview Road, do you sit in the front of the ambulance?
We do.
Take us to when you arrived to Fairview Road. What do you see?
You see a bunch of police lights. Canton engine 3 was already on scene, so we parked behind them.
Did you have it, without talking about what you spoke about, did you have a chance to speak to anybody at the scene?
We briefly spoke to the Canton police.
Yep.
They briefed us.
And be like, hey, what's going on?
Sent us to where the defendant was at the time.
Why'd you call us?
Why do you have a conversation with other first responders at the scene before you do anything?
So you don't just grab somebody?
They're making sure the scene is safe to begin with, and they're unseen first, so they have a little more info than what our dispatch would have.
After you had that debriefing with colleagues, were you directed to approach any certain person?
I was.
Where did you go?
I went to the defendant who was sitting in a black SUV type car.
Were there other persons inside the car with the defendant?
From my understanding, there was one person in the driver's seat.
From your understanding, or did you see
what seat was
it?
the defendant in?
She was in the front passenger seat.
Did you have a chance to speak to her?
I did.
And the person you spoke to who was in the passenger seat of that car, do you see that person in court today?
I do.
Could you point out and describe an article of clothing, please?
Miss Reed right there, she's in the blue.
They did a much better job this time identifying the defendant.
With the
They didn't do it very often last
seated
trial.
inside the vehicle.
Approximately 5.
And then I got fixated on it.
5 to 8 minutes.
At some point, did you and the defendant move to another location?
We did.
Where did you go?
So we went back in the ambulance.
After having a conversation with her, was she cooperative going back to the ambulance with you?
She was.
And did you ask her to be seated in the ambulance?
Karina, I'm going to answer your question
Cooperative with that as
if
well?
he doesn't testify to it.
After she was seated in the ambulance, did you close the doors and get in?
We did.
When you say we, who was with you?
Me and Firefighter Whitley.
So you and Firefighter Whitley were in the back of the ambulance with Miss Reed. Who was going to drive the ambulance?
Firefighter Sam Park.
Where did he come from?
He was on the fire engine that was already on scene.
I want to ask you questions now about
Where did
what
he
you
come
did in
from?
the back of the ambulance and some of the
He
conversations.
was on
that you had.
scene.
Tell us what your role is once you have a patient in the back of the ambulance. What do you do next?
I mean, each patient's different. Depends on what the call is for. In this specific situation, it was more a psych eval, because that's what we're called for. Initial triage questions: is the patient cooperative, uncooperative, combative? I asked her name, her mental status, where she was. I asked her if she was suicidal, and if she was, did she have a plan? Did she want to hurt anyone else? Those are some of the initial triage questions that I would ask.
Why do you ask those questions?
Just to get a kind of a judgment on the patient, reading the patient.
What's your role at that point? Are you an investigator?
I'm not.
Are you in any way law enforcement?
I'm not.
So what's your focus when you're speaking to a patient?
It's basically hearing them speak in their story. In this specific situation, We didn't know circumstances. We just knew that Miss Reed had found her husband, which she was gone dead on the side of the road. So it was a traumatic call.
So when you were there, you knew nothing about what had happened before you got there?
We did not.
And your role had nothing to do with any of that investigation?
We did not.
You were solely focused on caring for the patient?
Correct.
Did you have any other role other than caring for the patient?
Just making sure she got to the hospital safely. She didn't hurt herself.
During those conversations, are you and firefighter Whitley doing the same thing or different things?
Again, it depends on the call. I was the lead tech, so I'm the one documented, giving a report to the nurses, the staff. So I was more kind of getting that information, my initial triage questions, and then just kind of sat and supported Miss Reed. And
were you writing down information, technical information about status and health on a report?
I was, yes.
While you were doing that, was your colleague speaking to Miss Reed?
He was.
Did you have a chance at times to hear what they were speaking about?
Yeah, and no.
Needs to summarize it.
At other times, did you speak directly to Miss Reed?
I have.
Can you describe her demeanor, her temperament?
Initially, she was agitated because she didn't feel like she needed to go to the hospital. She said the statement she made, she didn't mean.
Right.
She just kind of said it just because of the events that she went through. So she did that, but then there'd be periods of which she'd be calm, and it would fluctuate. She would have like pressured speech, repetitive, but all in all, she was cooperative.
At some point, did you have a chance to speak to her directly about her mood?
About her mood?
About her mood.
I don't know if I understand the question.
Okay. Did she say anything to you about her last interaction with what she referred to as her husband?
Objection.
Sustained.
They
Did
keep
she make any statements to you?
This
when you were
ambulance
giving her
rig keeps
treatment?
referring to John O'Keefe as Karen Reed's husband because that's how she referred to him, and that's what's in their report. So they keep referring to John O'Keefe that way because that's how Karen identified to this rig of paramedics what happened. Remember, this rig of paramedics came after everything because Karen Reed had left with Carrie Roberts and then Carrie got a phone call to bring Karen Reed back to 34 Fairview. So they came back to 34 Fairview, said, what's going on? And then we're told they had a section 12 and then evaluated Karen Reed and then took her to the hospital. So that's why they keep referring to him that way. They're not going to correct their impression because they're going off of what they were told.
You're speaking to her about her husband.
Objection.
I'll allow that. It came in.
So one of the reasons why she was saying she would have stuff is because the last conversation she had with her husband at the time was an argument. I didn't feel like it was my role to really find out the details on what was said.
Look, a professional.
So she said to me.
But the last thing she said to him was an argument?
Objection.
Sustained.
Did she tell you what the argument was about?
She did not.
Inevitably, did you get a chance to bring her to the hospital?
We did.
Did you stay in the back of the ambulance with her?
I did.
Did you continue to have conversations with her?
Yes, I did.
Did you hear conversations or parts of conversations she was having with your colleague?
I had parts.
When you got to the hospital, what happens next?
So we brought Miss Reed into the hospital, registered her, bring her to the psychiatric section. Is it?
Thank you. I have no further questions.
Okay.
Mr. Jackson?
Thank you, Honor.
They did not ask, but there have been a number of questions in the chat about the Section 12. It has not been addressed a ton in this trial. It was addressed very quickly with Carrie Roberts' testimony, and there was a lot of other testimony from Carrie Roberts. But Carrie had heard Karen Reed's phone call with her father where she was threatening to kill herself, saying, if he doesn't live, I don't want to live, and told these paramedics, I don't think I need to be sectioned. I was saying stuff because I was upset. I don't I don't mean it literally. I mean it to try to express the level of frustration. And after that conversation that Carrie overheard, then she gets the call to come back. And I believe they asked one of the other firefighters if they know who called and said it was Karen's dad. But it was very quick testimony about it. So it's not I don't think it's readily apparent. Maybe it is to the jurors, but it moved pretty quickly. But it was ultimately her father that called law enforcement. I know from the last trial that they put in evidence of that call from her father to answer that question. I think the prosecutors have to do that so it doesn't seem like a ruse to get her blood work, because I could see how jurors could be like, well, are you trying to like end route getting her blood that you're using by having a Section 12? Who even called it in? Was it law enforcement on the scene? And why would they do that? And I can see where jurors might have questions around that, but they played the call last trial from Karen's father where he made that call. So I think we'll see that later. They just haven't seen it yet. So this witness I remember from last time thought that maybe, and they haven't gotten into it, maybe he'll get into it in cross, thought that maybe the Section 12 was a drastic response. Like it was a big deal. So he was like, he testified last time, we'll see if it comes up on cross, that he thought that her behavior on scene was consistent with the things that had happened that morning, saying that her response to that situation seemed in line with how difficult that morning was. I'm interested to see if he gets into it in cross, because he was very compassionate last trial and thought that maybe the Section 12 was a bit much, but once it's been called in, they are obligated to follow through by law. I'm interested to see if we get there. So as we move into cross-examination, yeah, she was released pretty quickly because she was back at One Meadows getting her car later that morning. They did not hold her for 12 hours or more. They released her pretty quickly.
Can I have just a moment, Your Honor? Yes.
Also, I don't think
it's... Good afternoon, Firefighter Becker.
Good afternoon.
Sorry, Jackson. You started talking just as I started talking. I don't think it's going to be staggering to the jurors, the testimony that the last conversation between Karen Reed and John O'Keefe was a fight, because what the jurors don't know yet is that there's a whole lot of voicemails. They heard a little bit about it in opening. Hearing about the voicemails in opening and hearing them in court in Karen's own words is really different. I don't think it's going to be a secret that there was an argument. So
when you first arrived at the scene, there was at least two Canton police officers there still.
Correct.
Do you remember their names?
Officer Saraf and Officer Mulvaney.
Okay. Their cruiser was there. You said that an engine was still there?
Correct.
And was there another ambulance there, or the other ambulance had already left the scene? They'd cleared?
They had already transported to the hospital.
Remind me, you were in ambulance 2?
I was ambulance 2.
Got it.
He's just...
You parked behind the SUV where you ultimately made contact with Miss Reed, correct?
You can't put your tail in my coffee.
I think it was more in front of the SUV because the way the SUV was parked.
Got it. Got out of the ambulance, ultimately made contact with Miss Reed through the passenger door.
Correct.
Had a short conversation with her there.
I did.
You said it was maybe 5 to 8 minutes?
More like 5 minutes because of the weather conditions.
Okay, nothing of great consequence. I'm guessing just an initial, I think you called it sort of a triage assessment?
Well, it's more of just introducing myself and asking her how she was doing.
Got it. And then there was one other person in the cab of the vehicle as well.
There was.
Female, male?
Female.
So there are 2 females, 1 Miss Reed, 1 another female. Did you see any other civilian females out there?
I didn't see.
Okay,
But
so at least where you were, the contact that you had with Miss Reed and this other female, there was just 2 of them, not a third one.
from what I saw, correct.
Did you get the other female's name?
Not at the time, I did not.
Okay. By the way, have you since gotten her name?
Look at how clear the answers are. Look at how clear. Just answering the questions. It's so nice.
Based on a conversation Firefighter Whitley and Miss Reed had back in the ambulance.
Got it. Okay. And who is that other person?
Miss Carrie Roberts.
Okay. When you first observed Miss Reed, did you note whether or not there was anything unusual about her physical appearance, meaning anything on her?
She did, yes.
Describe that for the jurors, please.
She had some blood around her mouth, her neck area.
At that point, were you concerned about, obviously you're concerned mainly about her safety and getting her safely to the hospital, correct?
That's correct.
Were you worried that that might be her blood?
Well, she had said that she had given CPR to her husband.
Okay, you jumped a question ahead. I was going to say, did she tell you that it was in fact not her blood?
She did, so that kind of, in a way, ruled it out.
Okay.
No injury for me.
And you didn't indicate, you didn't notice anything about her that looked like she was physically injured or physically in harm?
I did not.
Okay. She indicated that she had given CPR, mouth-to-mouth, attempts at mouth-to-mouth resuscitation to Mr. O'Keefe, correct?
She did.
And that would account for the blood on her face and in her hair and on her neck?
That's what she told me.
Okay. And based on your observations of her, you didn't have any reason to quarrel with that?
Correct.
Okay.
Right.
You indicated that her tone was somewhat rapid and repetitive. Is that right?
It fluctuated. So at times it was, yes.
Did it appear to you at that time that she had gone through a pretty significant trauma, as best you were trained at the time? Objection.
He's already nodding.
A little bit more of a foundation.
He was already nodding. He was already like.
Have you ever, in your course of training, seen individuals who have gone through some sort of a traumatic event?
Frequently.
I mean, he's a paramedic.
Everyone's different, though.
Understood. Obviously, everybody's got their own personalities and the way of dealing with those things, right?
Sure.
Have you been able to, through your training, assess whether, at least in your belief, your observations, if someone has gone through a relatively traumatic event, as opposed to just someone whistling down the sidewalk?
Yes.
Okay. Did it appear at that time, when you're interacting with Miss Reed, that she was showing the signs consistent of having gone through a trauma?
At the time, yes.
Okay. So, hence the rapid speech, the repetitive speech, things of that nature?
Correct. For her. For the defendant. Some people don't have rapid, repetitive
Understood.
speech.
I'm just talking about your observations of her at that time.
Yes, sir.
Her demeanor was consistent with having gone through a significant trauma.
For the situation, sure. Yes.
Okay. You said that she went from calmness to agitation. The agitation you accounted for being, I don't necessarily want to go to the hospital. I don't want to be sectioned, correct?
She felt like she didn't need to. It wasn't, she wasn't going to act on her comments about wanting to harm herself.
You called it, I think in a report, it's SI, suicidal ideation.
Correct.
That's obviously of great concern to you and your partners when you're assessing a patient, correct?
That's right.
You don't want to leave someone on their own if they're going to self-harm, correct?
That's correct.
You pretty quickly assessed, I'm guessing, Firefighter Becker, that she was not, in fact, in the position to self-harm, that I think you said that the statements that she originally made, if John dies, I don't want to live, were not necessarily at the level of actual suicidal ideation. Is that right?
Yeah, I mean, at the time I believed her because of the information we got and what she went through.
I'm sorry, I didn't quite understand your answer.
Sorry, can you repeat your question?
Of course. It's probably my fault.
She said
at the time that you assessed her, even though she had made some comments about if John doesn't live, I don't want to live either, you did not elevate that to the level of her being suicidal at that moment.
He believed that she was expressing grief.
I couldn't rule it out, but I didn't think it was a huge threat at the time.
Understood. That's what I was trying to get at.
Couldn't rule it out, so that's why we had to take her to the hospital.
Understood. I mean, you had a Section 12. You had to take her irrespective of what you ruled in or out, right?
Right.
Okay. Firefighter Whitley was with you in the back of the ambulance the entire time you were with Miss Reed, correct?
Not the entire time. He was, before we started transporting, he was kind of in and out trying to find more of, talking to the police officers, find more of a story of, what happened,
Okay.
why we're taking the defendant on a Section 12.
When he said, I believe her, he believes that when she was saying, if he doesn't live, I don't want to live, she was expressing grief and distress, not expressing a plan of some sort. So that's when he said, I believed her. I believed her when she told me, I'm not going to hurt myself. I am distressed. And he's been consistent in, and I believed her. People express distress in different ways, and people make hyperbolic statements.
Reed were in the back of the ambulance. Firefighter Whitley then joined you in the back of the ambulance?
He did.
How much time lapsed?
It was a couple minutes at the most.
Okay, so it wasn't a lengthy amount of time.
It wasn't lengthy.
And he was with you during the transport, along with Miss Reed, for the whole transport back to Good Sam.
Yes.
And you said on direct examination, I think your phrase was, all in all, she was cooperative with us.
For the majority of the transport, yes.
Okay. Never became combative, never got physical, nothing like that?
No.
Okay. She did refer to Mr. O'Keefe as her husband or her spouse?
That's correct.
You're aware of HIPAA rules, obviously. You're in the medical field, correct?
Correct.
You were aware at the time that HIPAA rules would demand or dictate that unless you're a spouse or a parent or a child, there's certain rules against getting or providing information to someone who isn't one of those close family members, correct?
That's correct.
Okay. You previously indicated on direct examination that, I think your words were, that Ms. Reed indicated that her last conversation she had with her husband was an argument, correct?
Correct.
You've previously testified about that statement in other particulars, right? Other hearings.
I have.
You're paraphrasing. You didn't write down what she said about her previous interactions with Mr. O'Keefe, and you didn't record those.
She said it's none of my business.
Correct? I wrote down in my report that she said she had an argument.
Right. You didn't write them down at the time. That was a bad question on my part. You weren't taking notes as she was speaking.
Yeah, it could have been. I mean, it just kind of for every call we jot down notes on a notepad, just so when we give the staff a report, we can read off it.
Do you have those notes?
I don't.
Okay. Do you think you took notes or no?
He made a report.
To be honest, I'm not sure. I could have been typing them on the computer. That's what we typed the report on.
Okay.
At the time.
Do you have an independent recollection of taking notes, either handwritten or on a computer, as you sit here right now?
I couldn't tell you if I did one or the other. Sometimes I write on the computer, sometimes I don't.
Or you might not have written anything down, correct?
Correct.
Okay. So, in any event, you weren't taking down, even if you were taking notes, you weren't taking down verbatim quotes of what she was saying. You were paraphrasing the information that was coming to you, correct?
That's correct.
All right.
And I think he was very good about saying, none of my business. None of my business. She said she had an argument. She was clearly distressed. None of my business.
You previously said or testified that the last time, let me rephrase that just a little bit. You previously indicated in recounting what it was that Miss Reed actually said to you was something along the lines of she was upset because her last words to him were because of her last words to him being in anger.
I object.
I'm going to allow the question.
Is that correct?
Well, I probably phrased it a little wrongly. The last words. It was the last conversation.
Okay, that wasn't my question. My question is a simple one. In a previous hearing, did you use the phrase "her last words to him"?
Yes, I did. I did.
And that was at a hearing where you're under oath, just like you are now, correct?
Correct.
That was a little closer in time than we are now. It was maybe a year ago, correct?
Correct.
Actually, my mistake. It was about 2.5 years ago. It was a grand jury, correct?
Grand jury, yes.
Okay.
He also testified
and
at the last
phrase
trial.
that you used was, and I want to concentrate on that for just a quick second, Firefighter Becker.
Sure.
The phrase that you used at that time was that she said quote, like her last words to him. She was upset about her, quote, last words to him. Is that right?
I object.
All right, can I see counsel at sidebar, please?
Okay.
May I
Last
continue, Your
words
Honor?
Yes.
versus last conversation.
When you were
Here's why I think it matters to AJ, and sometimes I will give him a very hard time if it feels like he is just picking and I can't see the point. He is going to have one. But I think the difference in this is not just being picky with the words, because there is a big difference between last words to him versus last conversation, given what the jury doesn't know yet, but what we know, which is last conversation would necessarily be when John O'Keefe was in the car outside of 34 Fairview. Last words to me would be those voicemails. And the voicemails are angry. They are pissed. So I think there are times where it might be a distinction without a difference. This, I do not think, is a distinction without the difference. I think this is actually a really important distinction for the defense, that last words versus last conversation really is a very big difference in time. Is it in the car at 34 Fairview? Is it the voicemails? Is it both? The jury will get to decide. But I do think this matters a lot to the defense, and I think it's important for the Commonwealth as well.
Counting the conversation that Ms. Reed indicated that she was upset about, you also indicated, in addition to using the phrase her last words to him, you also said that it was earlier in the night, correct? They had an argument earlier in the night.
I don't recall.
The jury has seen the day before this, all the texts back and forth. So the context around argument earlier in the night
just a moment, Your
has
Honor.
context for them based on the back and forth of the, are you coming here? Are you not coming here? We've gone round and round. So this testimony is coming right after those text messages for the jury.
May I approach?
Yes.
I think we are
If you
refreshing
don't mind,
recollection.
take a look at the top paragraph, very, very small print. Let me know when you've refreshed your recollection.
Yes.
Great. May I approach?
Yes.
Thank you, sir.
You got it.
When you wrote your report, you had indicated that when she was describing the argument that you testified to on direct, it was about an argument that was, quote, earlier in the night.
Earlier in the night, correct.
Okay. And then you recounted that statement, that same statement in the grand jury later on as at least including, quote, her last words. Is that right?
Her last words.
You were talking about an argument that they had, and then she was upset, and you were paraphrasing her. And one of the things that you paraphrased was, in fact, your statement was she was upset that was like her last words to him, correct?
Like
She
her
said
last
that.
words to him.
Yes.
Correct.
Okay.
Okay.
Were you also made aware, did she tell you that her last words to him were in voicemails? Did she say that?
There it is.
She didn't give any details.
Did you ask her, what were your last words to him?
I did not.
Did she ever say whether or not she
Good
believed
questions for him.
he ever received her last words to him?
There's
i.e. in
no other
voicemails?
details than
Say that
there was
again?
no other details other than what
Those
she
are
said.
good. That's a
Okay.
good line of questioning.
But she did, when she was having this conversation with you about her last words to him, she did actually take out her phone and show you a bunch of missed calls to him at the same time, didn't she?
She tried to, yes.
Okay.
Interesting.
In your mind, did you put two and two together that what she was actually talking about were the missed calls and her being upset about her last words to him being very angry on those missed calls, those voicemails? Did you put those two things together?
I didn't.
Okay. Thank you.
He's made his
Okay,
points
Ms. Brennan.
really well. I think the defense made their points really well at the end of that cross. Because the voicemails haven't come
Ms.
in
Reed
yet.
told you that she was
And I think that's important. When she said her last words and she was showing you on her phone all the missed calls, I think that that solidifies what she is talking about. And then he asked the question, did she tell you if she thought he heard her voicemails? The jury doesn't know yet. Like, the jury is just left hanging with this, but the point will come back around. If Karen Reed is in the ambulance thinking that John O'Keefe heard all those voicemails, and this point I don't think was made nearly this well in the first trial, to my memory sitting here today. But if she thinks her last words to him, he's listened to, all of those were made after she left 34 Fairview. So if the prosecution's going to argue that Karen Reed knew she hit him, remember, count 3 requires Karen Reed know that she hit him and leave him there. Count 1 requires that she knows that she hit him and chose to do it. If she knows that she hit him and chose to leave him there, then why is she afraid that he heard the voicemails? I think we will see this come back around in argument. It's come in much clearer. I don't know if they made this point last time, but him remembering her holding the phone, trying to show him the missed calls, and then leaving the question out there, did she seem to think you, or did you understand that she was thinking he had heard those last words, is a really important point. I found the voicemails really persuasive last trial. We'll see how they come in this trial in the context of everything else. But it's interesting to see where the defense is going to go potentially with that line of argument, that Karen Reed is freaking out in the ambulance because she thinks John O'Keefe has heard all of those horrible voicemails before she found him in the snow. Interesting to see. So let's continue on. That point, I think, if it was made last trial, it has been forgotten by me, but it came in really clear at this point. Stephanie asked a great question in the chat. Could the prosecution not put them in? No. I don't think the prosecution can choose to not put the voicemails in based on their theory of the case. No, not at all. I think they have to. I think they're going to. The voicemails are horrible, but the context begins to make sense. And I think everyone on the jury and everyone in life can think of things they've regretted saying in anger. Is it a motive? We'll see how they put these in, and we'll see how they come across. Will it be harder this time, though, with her media interviews? Do the media interviews change the context of those voicemails? We'll see. But AJ made a great point, I think, in this cross-examination. I think that was a really, really, really good cross.
Bad because her last conversation, her last thing that she had said to him was an argument. Did she ever suggest that was in a voicemail?
Objection.
Did she ever suggest it was in a voicemail?
She did not.
Did she ever suggest that she didn't actually speak to him, but instead it was some type of message?
Objection.
I'll allow that.
Did she ever suggest that?
She did not.
In fact, you wrote a report saying that there was an argument earlier in the night, didn't you?
Objection, Your Honor.
Sustained.
You then were interviewed, weren't you? Were you
Yes.
interviewed on February 14th, 2022?
Yes.
And you referred to the fact that she told you there was an argument earlier in the night?
Argument early in the night.
Okay. And she was telling you this when you were speaking to her that morning?
Correct. Around 6 a.m. Yes.
And earlier in the night, do you know if she was referring to 12:30
I did not know.
or 12:15
No.
or midnight?
I didn't know the time.
So his answer is he doesn't know.
That's
You
a
testified in the
sustained
grand
asked and
jury,
answered
and Attorney
objection.
Jackson just asked you some questions about
Of
part
course, just
of
like,
the statement you made to the grand jury.
done.
When he said, like her last words. Would you like to put that in context of the whole statement you made? Do you remember
Her last words.
Do you remember the entire statement that you made in the grand jury about the statement that was made to you?
I'd have to.
May I approach?
Yes.
They are taking a look at the transcript to refresh his recollection.
Lines 1 through 4. Please read it to yourself.
Right here, sir.
1 through 4, please.
Rachel ID says, do you think there's a chance the Commonwealth doesn't bring in the voicemails because it cuts against their case? I don't think they see it that
Yes.
way. I don't think they see it that way. I don't think they see it that way at all.
Now, when you made that
like
statement,
everything in
you were
this
asked
case,
about
I
in the
think there's an
grand jury,
argument
you
on
didn't
both
just
sides of
say,
it.
like her last words, did you?
No.
You explained your memo.
Courtney asked they can mention grand jury. Yes, they've already talked about the fact that there was a state grand jury in this case and that there were multiple grand juries. Grand jury doesn't insinuate a state proceeding versus a federal proceeding. Residents of Massachusetts may know that a lot of their cases are charged by grand jury versus preliminary hearing. So that doesn't intimate a prior trial or anything like that.
Memory to the grand jury?
Objection.
Ask him what he told the grand jury.
Okay. The grand jury, do you know it was on April 21st, 2022?
Yes.
Okay, and did you tell the grand jury? So she
I'm going to see counsel at sidebar for a second, please.
The court is not happy. Thank you, Team Baker, for the edits of the long sidebars. The court is not happy with that at all.
So I'm showing you that statement that you made. That includes last words. But there's more to the statement, isn't there?
She was upset.
I'd like you to read
Oh,
your
sorry.
entire
Sure.
statement, 1 through 5. You can read it out loud.
So she was also she was upset also because she said they had, the last time they had talked, she had gotten into an argument. So she was upset that that was like her last words to him.
Last words. Okay.
And so when you were speaking about her
Again, the jury will get to decide.
last words to him, were you referring to the argument?
Correct.
It's a fair
You
point.
testified again regarding this issue, didn't you, in May 3rd, 2024?
Correct.
And at that point, did you think or believe that the conversation she was relating to you was about a voicemail?
Objection.
I'm going to sustain the objection.
Your point's been made, Brennan.
Did you use the word again
Okay.
on May 3rd, 2024, argument?
Objection.
You know how AJ made a really good point? The redirect gives you a whole lot of scope about how impactful Brennan thinks that testimony might be. Because Brennan is fighting to redirect. He's asking it like a cross-examination, but he's fighting to redirect to overcome the questions of Alan Jackson. And he might end up just highlighting that. He might, the more he says voicemails, the more it highlights the point of the voicemails. But Brennan's worried about it because he will not move on. And she is sustaining objection after objection after objection.
I'm going to allow this.
I used argument.
May I approach, Your Honor?
Yes.
He's said both. He's said both.
Can I ask you to read your prior statement on page 10, lines 9 through 13?
Objection.
I'm going to see you at sidebar again and bring these documents. Please bring all of it.
Bring all of it.
May I?
Yes. I'm sorry.
Thank you.
Judge Canoni, bring it up here now and stop it. Brennan is Brennan's a defense attorney. It's really hard sometimes to do these questions on direct exam, especially if most of your work is cross-examining. It's way easier and more fun. His direct exams have been good. When he gets into redirect, you can see the struggle where he's just like, it's so much easier when you can lead on cross-examination. Yeah, it is. It's so much easier when you can lead.
Sir, when you wrote the report of your notes to put in your report, do you remember the word argument?
I did.
Do you remember her actually saying the word argument?
I did.
Do you remember her ever saying any word about voice messages?
I did not.
You said that there was somebody in the front seat of the car with the defendant?
It was.
And you later learned from the defendant it was a person by the name of Kerry Roberts?
Correct.
Can you share with us the context? How did you learn that?
The defendant and my partner, firefighter Whitley, had a conversation.
I'm going to allow it.
So she
That's
the
not
defendant
being offered for the
brought
truth,
up how
which is why it's being allowed.
if her husband had died at the time, she didn't know how she was going to take care of his kids.
Objection.
I'm going to allow this.
And firefighter Whitley mentioned that she had like a strong support system. You know, all the friends are on Canton, and
Objection. May we approach? Yes.
He's like,
when you spoke to the defendant and she shared with you that
this witness is like, I am trying to just answer what's asked. I am trying to just answer what's asked. And I can imagine how frustrating it is as the witness, because he, I'm sure, feels like he's doing something wrong and he's not. He's answering the questions that are asked. And he's just like, I'm trying to answer what you asked me. And the questions are being allowed from the court. The reason I think the court is allowing them, of course, without the attorneys having grounds for hearsay, because the court doesn't allow it, which annoys the shit out of me. But these are not being offered for the truth. They are being offered for the complete conversation of Karen Reed's statements, and Karen Reed's statements are allowed to come in. Plus, Whitley has already testified. So Whitley's information is allowed to come in.
her last words with her husband were an argument. Why didn't you ask for more detail about that?
He said
I didn't feel it was at the time we went about the call as that we didn't think we would be witnesses in a murder trial. We were there to support Karen and ultimately get her to the hospital safely.
And you were asked about
He
trauma,
said that.
and you said that you observed that the person may be in trauma. Ms. Reed.
Moving on.
A traumatic event,
Traumatic event.
Right.
Do you have any idea what caused that traumatic event?
I did not.
Thank you. I have no further questions.
Anything?
Very briefly, you indicated that you were asked on redirect examination by Mr. Brennan whether earlier in the night could have been 12 or 12:15 a.m., correct?
That's what he asked, yes.
And earlier in the night could have been 6 o'clock p.m.
Early in the night, yeah, correct.
Could have been 5 o'clock p.m.
Could have been.
Could have been 7 o'clock p.m.
Sure.
Okay.
Right.
You were also
Good job,
asked
babe.
whether or not
right.
Ms. Reed actually specifically mentioned voicemails when she talked.
The reason I think it's good to bring it around to that, because the jurors just saw all those text messages at the end of testimony the day before this testimony. They saw the back and forth about the hot water heater and the Facebook following and the rest of it. And I think that's helpful when he's saying earlier could be earlier the night before. Okay.
About those last words. And you said she didn't.
That I remember, correct.
But she did show you her phone.
She tried to.
And she did show you a bunch of missed calls to John O'Keefe, correct?
I wasn't going to look through her phone. I don't know who she called.
Thank you. That's all.
Right.
When she said about the argument, she said those were the last words, the argument, right?
That's correct.
Sustained.
All right. Jurors disregard that last statement. All right, you are all set.
All right. Thank you. Thank you guys.
All done.
It's a good place to stop for the day.
If the court pleases, yes.
Jurors, we could do 6 minutes, but I think we'll just.
If the court pleases.
So, as I understand it, folks, we're on schedule, right where we thought we would be. We're going to release you for today. Now, when I told you this morning, and I've told you other times too,
Dun,
that
dun, dun, dun.
when you're out in that room waiting for us, we're in here getting work done to make things more efficient for the trial, especially a trial this long. We've decided that we're going to spend Monday afternoon again trying to streamline this trial and deal with issues that we have to deal with. So Monday for you will be a half a day. All right, so I just wanted to tell you that before you left today. Please, again, those 3 cautions: do not discuss this case with anyone. Don't do any independent
Monday
research
definitely
or
wasn't a half day
investigation
for
into
us.
this case. If you happen to see, hear, or read anything about this case, please disregard it, let us know. And I guess the 4th caution is the same as I've been saying. Please be very careful with your social media. All right, have a good weekend. We'll see you Monday morning.
All right, everyone, please.
And I'd like to see counsel at sidebar, please. All right, we'll see you Monday.
I'd like to see counsel at sidebar, please. Knock it off.
So, Tori.
And that is the end of day 4. Just 2 witnesses testified on day 4. We got into the paramedic partner of Dan Whitley, who was with him when he transported Karen Reed to the ER on the Section 12. And we got into the foundation from Good Samaritan drawing Karen Reed's blood after the jury view. I think the points that were really made on the first witness with regard to Good Samaritan is that the Good Samaritan Hospital lab is a medical lab, not a forensic lab. I know in the first trial, the defense brought a lot of, not objections, because that's not legal objections, but a lot of points about the difference between the lab testing, the fact that the blood taken from Karen Reed was not being tested for forensic purposes. It was being tested for treatment purposes. I have to wonder if in this trial, with the various clips of her that the jury's already seen where she's talking about drinking and driving, if it will matter that much, or if they are going to say, yes, she was drinking and driving that evening. We've heard her talk about it now, saying in clips things like, oh, I can see in the videos of me driving, I'm driving slowly, and that's how I drive when I drink and drive. So, and her talking about, well, the Commonwealth is saying I did 9 drinks, but it was really more like 6 drinks, and the drinks were really weak, so I was putting shots into the drinks because they were weak, and I didn't drink all of this shot, and I didn't do this and that. So it's going to be interesting to see if the point about the blood draw matters as much now that we have those interviews that Karen Reed did between the 2 trials, and even some of the interviews that weren't brought in at the last trial, but are being used now. I don't know if the difference between the medical lab and forensic lab will really matter to the jury all that much. Then we got to the paramedic. What stuck out to me in cross-examination is that Jackson was asking about Karen Reed's last words or conversation with John O'Keefe and how this paramedic remembers what she said. Did she say she was upset because of her last words to the decedent, John O'Keefe, or was she upset because of her last conversation? I think it's a point that matters very much, because last conversation could well be in the car at 34 Fairview, where last words could well be interpreted as the voicemails that are yet to come into evidence. And I think Jackson made a good point that I don't remember from the first trial, where he said, and when she was saying her last words, she was showing you how many missed calls were on her phone. And we know that Brennan was worried about this point, because in redirect, that is what he was hammering in on, that Karen Reed never said voicemails. She said their last conversation was an argument. It will be for the jury to decide how they interpret the paramedic's words, saying her last words to him, her last conversation with him, and seeming to use those a bit interchangeably as he was summarizing what he remembered. The reason he was asking Karen Reed those questions is because of the Section 12. And she had said and been overheard, or not overheard. She had said to her father, if he doesn't live, I don't want to live. I'm not going to be able to take care of the kids. She said that part to paramedics as well. And they were inquiring about that before taking her on the Section 12 hold. And she said, essentially, I don't literally mean those words that I'm not going to live. There's not a plan, but I'm upset because our last words or conversation were an argument. And they were talking about an argument earlier in the evening. And Hank Brennan was saying earlier in the evening could be 12:30. And Jackson said earlier in the evening could be 6 p.m. because the jury has seen all the text messages between Karen Reed earlier in the evening with John O'Keefe, going back and forth about the Facebook friending and the hot water heater, and alluding to an argument they had had the night before that and had woken up in the morning and was still carrying over because they had not resolved the disagreements that they were having in their relationships that had spilled into the day of the 28th and then overnight into the 29th and the morning of the 29th. It will be up for the jury to decide. I think good points were made on the cross-examination, but the jury hasn't heard the voicemails yet. So will those points be remembered by the time we get there? Maybe. But I think they did a good job of pointing out that there are two interpretations of what Karen Reed is saying to law enforcement. And remember, at the end of this case, we will get to the jury instruction that says if there are two reasonable interpretations, you must pick the interpretation that leads to innocence. And that is one of the things when you have cases with circumstantial evidence, the jury gets to interpret what that evidence means, and the jury instructions tell them that that interpretation, if two are reasonable, must point towards innocence. And that is why we are seeing the arguments of both sides are going to continue to come up. And the interpretations of things two ways are going to continue to come up. You build the case towards your closing. And I think we're seeing both sides bring in the points. Like, you can almost, for me, see the bullet points that the attorneys are highlighting that they want to make in closing. And you can feel that today the defense was like, and I want to argue she was upset because she thought John O'Keefe heard the voicemails. That takeaway undercuts count 1 and count 3 significantly if the jury believes that part of the reason Karen Reed is so upset the morning of the 29th when they find John O'Keefe is because she thinks he might have heard all of the voicemails that she left him and that those were her last words. The prosecution, of course, is going to argue that their last words were a fight in the vehicle at 34 Fairview. However, I also think it could be both. And I think we are going to see clips of interviews where Karen Reed talks about the fact that they were having discourse at 34 Fairview about whether John was going into the house, whether he was going to come out and tell her if they were going to the party or not. And we haven't seen those clips to my memory yet, but we will, I think, see those clips of her talking about John going into 34 Fairview and her waiting and waiting outside. But then again, maybe we won't. That's my memory from watching some of the docuseries. So I think that might be where they're going, but we'll see if they choose to play that clip or not. Maybe they won't, because in that clip, she says that John O'Keefe goes into the house at 34 Fairview. So maybe the prosecution will choose to leave that out. And remember, the defense can't bring those clips in themselves. If they want Karen Reed to talk about it, then they have to put Karen Reed on the stand to explain, yeah, when I drove away from 34 Fairview, I was pissed because I was sitting outside in the car waiting for him to come back out of 34 Fairview, and he didn't. And I was mad, so I left. Because the defense can't bring it in through the interviews. Maybe the prosecution will, maybe they won't. We're going to have to wait and see. Law Nerds, don't forget to get the Law Nerd app, because that will keep you in the loop when we are streaming, what we are covering. I hope the summary of day 4 was helpful. Let's answer some questions. And then I need to get ready for Metallica. I need to get ready to Metallica. Savannah said, Emily, just so you know, there's no Limp Bizkit tonight. Oh, I know. Limp Bizkit's Saturday. Tonight is Pantera, and I forget the other opener because Pantera. No, I know, but what? Fred's just like, what are we doing? What, Fred? What, Fred? What? So anyway, all right, let's get to some questions, shall we? It's time to play I have questions. Feisty Pizza in the chat asked a great question. Feisty Pizza said, if you miss a day of trial as a juror, are you automatically removed from the jury? Feisty Pizza, you have no idea what delight you have uncorked, because a while back we went down a significant and delightful rabbit hole regarding a First Circuit case about this very issue. And we'll link it below. We were talking about Karen Reed's appeal. And what happened in that case was that they had picked 13 jurors and they had dismissed an alternate. But when they dismissed the alternate, what they didn't realize for like 2 days is that there was another juror just missing. And what it seemed happened when we dug down the entire rabbit hole of case law on that case is that one of the jurors that was selected was not allowed to sit with the jury by a member of court staff or bailiff or whoever. And they're like, no, I'm a juror. And they're like, no, you're not. And that juror's like, fuck it, I'm out. My interpretation. So when they released the alternate, they didn't realize that they had gotten down to 11 jurors. And there was just a juror freaking missing. And so as we were talking about her appeal, we went down the rabbit hole of this case that she cited to go through what the heck happened to a juror that was just fully fucking missing for days of testimony. But if you are a juror and you are going to miss court knowingly, it's normally discussed with the court. Sometimes the court will choose to replace that juror with an alternate. Sometimes the court will choose to take a half day or end early. So the court can say, oh, we're ending early today because the juror needs to go to Metallica. I mean, because who doesn't? Or they can, if the juror says, a family member has a medical emergency and I am unavailable for like the next 2 weeks, then the juror would probably be replaced. So as long as there's open communication, it works. But there are circumstances where jurors get into, I worked in LA, so vehicle collisions were not uncommon, where a juror would get into a collision and be like, I can't make it today. I know I'm on jury duty, but can't come. It's part of why you have alternates. So yes, if you are going to miss any testimony, you will no longer be a juror, but sometimes the court will accommodate jurors if it is a scheduling issue, like I need to leave early today for a graduation. We're getting into May. It's gonna be May. It's actually May. So we're getting into like graduation season in May and June. And if somebody's like, hey, we've got a thing, the court might just take a half day. So that is a great question with a very long answer. But hopefully it was helpful. LJ said, Emily, do you think the state is purposely having their witnesses out of order to make it more difficult for the defense? No, because I don't see the witnesses as out of order. Now I sound like one of the witnesses. Emily, it's a yes, no question. Can you answer yes or no? No. I don't see it as out of order for them. I think Brennan has a very strategic purpose about how he wants to tell the story of this case. I don't think that was directed around what the defense may or may not do. I think the side effect is that it is making things difficult for the defense because they can't just copy and paste their last cross-examinations because different evidence is in or not in evidence yet. I think it is making it difficult. I don't think that was the purpose. I think the purpose was to highlight the most, I think they think the most damaging testimony early on, so it is in the jurors' minds. I also think Brennan very much looked at Karen Reed's media interviews and decided where he wanted to splice those in to tell the story. And he's following along what he said in his opening. So the pattern of opening for the Commonwealth is following the way the witnesses are coming in. So I think it's intentional, but not intentional to mess with the defense. So it's going to be real interesting if we leave all of law enforcement to last. Then that's the last thing that the jury sees. And then you get into the defense case. I don't know if that's going to help either. Jay asked, are her media interviews damaging? I think a lot of them are. And I think they're going to be used that way. But when we get to the end of the case, we will see. Because I think some of the interviews give her explanation without her having to testify. So not all of them I have interpreted the same way the Commonwealth has interpreted. I also don't interpret the voicemails the same way the Commonwealth seems to, but I think some of them are damaging. The drinking and driving stuff, I think, is now almost a moot issue because I think those interviews will carry the weight of it, but she's not just being prosecuted for a simple DUI. So we will see how that goes. Let's see. Piper Lou asked, why was this not a manslaughter case and is that a lesser included? Piper Lou, count 2 is a manslaughter. This was originally charged as a manslaughter case only, and then they added counts 1 and 3 with the second degree murder and the hit and run causing death. They elevated those charges, I think, after her cell phone extraction. I don't agree with that decision. So it's very difficult for me to wrap my head around why they did it. But count 2 is a manslaughter. And then there are even lower degrees of non-volitional crime as lesser included of count 2. Count 2 is incredibly convoluted. I've talked about it a couple times, but count 2 is incredibly convoluted. I don't know if they will explain it better this trial or not. I don't know. SF said in Super Chat, so some of the first responders claimed to hear Karen Reed say she hit him, but not noted it in any report. Correct. That's not all in evidence yet, but at the end of the day, correct. And I can't unknow what I know. Could any of them amend their reports within a week or two had they actually remembered her alleged statement? They absolutely could have. Reports get amended all the time. But generally when reports get amended, it is to add new information that they have subsequently received because the report is supposed to include a summary of all of the information. All of it, especially the most relevant information. So when the Commonwealth is using it as a confession, it's real hard to say she said that she hit him and that's a confession, but none of law enforcement seemed to think it was important. So it's a real hard argument for me. Real hard argument for me. Rackens Reviews asked a very, very important question in the chat saying, Emily, was Antonio's Pizza by the Slice there when you were at UMass? Yes. And I remember it very fondly. The way I loved Antonio's. Oh, such good pizza. Such good pizza. Becca Andrews said doing media interviews before the retrial just seems like a risky move. It's a very risky move. It's a very risky move. I think the defense is confident in what the coroner will testify to and what the reconstruction experts will testify to. And this is me just speculating, that the defense looks at the evidence of the car, of the coroner, and of the accident reconstructionist and says, with everything that is there, her explaining in interviews is not going to hurt her, because the ultimate fact of the matter from the defense's point of view is that the coroner's report, the pathology, the accident reconstructionists do not line up with being hit by a car. And I think that's why they made that choice. The difficult thing is, if you have jurors sitting there, and it is not uncommon for people to be like, she was the last person with him. No one saw him come into the house. No one, and again, the defense is going to argue that point, but I can see jurors saying, every single witness comes in and says, we didn't see him in the house. They're probably going to get a text message that says, remember to tell them the guy doesn't come into the house, but we're not there yet. So you've got an interview of her saying, could I have clipped him? Could I have incapacitated him? I think those two things could be a struggle for the jury. But I'm very interested to see how the accident reconstruction testimony comes in this trial, because the pathology report's not going to change. And the pathology report is something that is very difficult for the Commonwealth to overcome. And if you're working as a prosecutor and you are looking at a coroner's report that is difficult to square with your evidence and your charges, maybe those aren't the right charges. Because if the coroner's report does not square with how you are saying the crime happened, then how does the prosecution prove their theory of the case? We'll see. That aside, that information hasn't come in yet. And I think the prosecution has done a better job of putting their evidence in. I just wonder if that's going to start to slide. Are we just going to get a precipitous slide from here? I don't know. I don't know. All right, let's continue. Clueless asked, what are they saying at sidebar and why is it off the record? Just for clarity, it's not off the record. The sidebar is on the record outside the presence of the jury. The jury does not hear what they're arguing at sidebar, because you can't unring the bell no matter for whom it tolls, and you can't put the shit back in the horse. Once the jury hears something, they're like, oh, interesting. Jurors disregard that. They're like, right, but brains. So they argue over those things at sidebar, because sometimes that evidence is not going to come in. That question can't come in. The argument around it can be unduly persuasive. Also, allowing the argument of objections in front of the jury can end up in what we saw in the New Mexico case in the Rust Armorer trial, which was all kinds of information just spilling out in word vomit in front of the jury because the attorneys were just bickering on the record back and forth nonstop, just off the rails. So this keeps it much more constrained, but sidebars are reflected in the transcripts. In this case, the sidebar conversations are impounded. So the sidebar conversations from the first trial are under seal, and they are under seal in this trial as well. So let's see. Thank you to all of you that got we're going to have song references for days. Shane, it's good to see you. Today, it was a slow day. It was a half day, but it's a Metallica day, so it's fine. Shane, I'm sad I will not see you at the banquet this weekend because Metallica's 2 nights. And I love that Metallica's like, we banged. Thanks, everybody. Metallica's like, we're going to play Thursday and Saturday instead of like Friday and Saturday. I don't know what's happening. I thought the show was going to be Thursday and Friday, and I looked at the dates and I was like, oh, wait. There's a day in between. I mean, good for them, but also, okay. Charlotte, EDB or anyone, did we ever get the link to your ADHD glasses? I'm desperate. I can't have my cell at work, and I work in corrections. They are Irlen lenses, IRLEN.com, and that is down below. So the tint is a specific type of tint that can be used for a variety of reasons, but the website will help you find a provider in your area. It is a whole process, just a whole process. Wedge, good to see you in the chat, said, I love that all these expert witnesses always treat these testimonies as their own conference lecture. Oh, sometimes they do, especially when we get to, let me show you the tool that I created. They definitely do. They take, this is why they're the experts. They take it very seriously. They take it very seriously. Angel said, 1 tickets to Metallica here in Blacksburg just came in just like 10 seconds ago. 10 out of 10. I am so excited for the 2-night shows. I am sad that I am not going to have more concerts this summer. Summer concert season is the best concert season. I'm going to be sweaty. I'm going to be disgusting. I'm so ready for it. A couple of you asked what I'm wearing tonight. I am torn. I'm not sure what I'm wearing tonight. We've got the Ride the Lightning nails. That's where we started. Some variety of black and probably a hat because A, it might rain tonight. B, it's hot. C, I'm going to be sweaty. And if I have a hat on, this is the real. If I have a hat on, it will prevent me from absolutely wrecking my neck because I'll be like, I don't want my hat to fly off. I don't want my glasses to fly off. I need to be restrained. There are times though that as the music starts happening that I forget that I am not 20 and then I can't move my head at all the next day. Bryn said, counting this as studying for my Crim Pro final, 10 out of 10. And I think that without being able to say the grounds to the objections, it's probably pretty helpful for evidence. But for criminal procedure, the use of the blood today, I think, is a very interesting question for Crim Pro because the rules about testing blood have changed since I was in law school, but I think it's very helpful. So hopefully it was good. Truth and Transparency asked Hamley, how significant is it that Jen's iWatch shows she takes no steps between 12:25? I haven't seen that in evidence, so I don't know how significant it is. We'll see if it comes up in her testimony tomorrow, but that's nothing from her watch is in evidence at this point. So we'll see when it comes up and talk about it when and if it comes up. But right now, I guess the answer would be it has zero significance because the jury doesn't know it. So maybe that helps. Donna said, I've missed this somehow. EDB, will you explain if you know why the DOJ and or the FBI, the who? The what? The FBI is indirectly involved in this case, please. So the way they seal things makes it really hard, but the best that I can gather, and this is the best that I can gather, is they are investigating this investigation based on the fact that they were getting most of the case file from the defense, not the prosecution. And based on the fact that they did a very extensive and long-ranging grand jury, and they were interviewing people in 2023 before the last trial, a year before the last trial. So that is my supposition. I hope that we will learn more, but they were looking into their own accident reconstructionist. That is really significant to me. It seems that the feds are not going to be looking into, did Karen Reed hit John O'Keefe with the car? For the purpose of charging Karen Reed with something, it's not going to rise to the level of a federal crime. There is no jurisdiction there. Why else then would they want to answer the question for themselves with accident reconstructionist? Was John O'Keefe hit by a car? And this is where my train of thought goes. If the feds want to know if John O'Keefe was hit by a car, why? They're not going to be charging Karen Reed with that crime. Well, Karen Reed is charged with that crime. So what are they looking into? And to me, that comes up with they are looking into things surrounding this investigation. And that is purely my supposition on it because they do not comment on open investigations and they do not give information on grand juries unless and until there's an indictment. So we have to go with what we know, which is they hired their own accident reconstructionist to look into this case. And they brought in a lot of witnesses in this case to ask them about it. Well, hey, Georgie, we got all the cats today. My bird feeders bring all the cats to the office. I know. Do you want to say hi to the law nerds, buddy? No, because Travis isn't here. Emily, why do you have bird feeders? So I have company. So I have company. And also I'm amused. LJ said, question, is the FBI case closed and can it be reopened to get the police? If there was evidence there that they could charge, and the threshold to charge cases for the feds is incredibly high. It's high anyway, but it's incredibly high when it comes to the feds. Could they reopen it? If it's closed, yes, they can. They would if there's new information that comes to them. I don't know what information they would turn up at this point. Because I would think that all the information about the investigation should have been dug up by now. However, we were still learning new shit about all those videos from Canton PD as of a few weeks ago. So maybe there still is new information to turn up. I don't know if they are all, they have said the case is closed. We know that ARCA is no longer under contract with the feds. Does it mean that if new stuff comes up, they won't take a look? They can reconvene a grand jury. There's a lot they can do. So yes, they can. It just depends on what they have now. And it depends on what, if anything, is unearthed later. But it can. B. Vargas asked, do you have any idea how the Birchmore case got involved with the feds? I don't know. I covered the Birchmore case very briefly. It's on my docket to go back and look at. I think there's a lot of interconnectedness, but I don't know how it got onto their radar. I can tell you from working with the U.S. Attorney's Office, both when I was in law school and then when I was prosecuting cases, I worked in a completely different division. And Peter at Lawyer You Know's dad is probably 100% the better resource for this. So check out his discussion because he has been like a head, big boss AUSA. I worked with them as a state prosecutor and as a law student, not the same at all. But in the division I worked in, a lot of our cases came from tips. Like a lot of them came from tips. So could that be the thing? That could absolutely be the thing. Who would have made that tip? I don't know. But could that be part of it? Yes, it could be part of it. We'll see. But the division, I worked in the tax division because nerd and I was fascinated. So many of the cases we were looking at came from tips. Disgruntled employees, disgruntled spouses, disgruntled non-spouses that wanted to be spouses, that weren't spouses, that were maybe to the side of the spouse. Like the people that know would definitely drop a dime. So a lot of our cases that I handled started with tips. So it just. Shelley said EDB hates math but worked in the tax division. The accountants did the mathing. The forensic accountants did the mathing. I did the nosiness. Look, man, you want the tea on what the fuck people are up to? Taxes. It's why I really loved all of the computer crimes, the financial crimes. The tea is in those bank records, honey. You can't hide it. All of the tea, all of it. And yeah, when people are pissed, hey, IRS, it'd be so interesting for you to know this. Tips. Then again, we know some tax prosecutions come from flaunting cash on Real Housewives of New Jersey. So you never know. Chris says nothing says payback like going after someone's money. 100%. Sherry, thank you for this question. I know we covered it. I just wanted to make sure I had. To everyone who gifted memberships today, absolutely. Thank you. Arizona Gal 89 said, I just became a paid subscriber. Welcome. Emily, love your channel and legal analysis. Much appreciated. Thank you. The law nerds get it, The non-law nerds don't get it, and we always see that more during trial. But what I love about trials is though some people will wander through and just be like, damn, this is annoying. They'll wander right on out. So many people wander into our community because of a trial and they're like, I found my people. And that is just the best thing to see in trial. Like, I found you, my people on the internet. Here we are. JC said, are tips truly anonymous? I'm going to plead the fifth. Jen said, are jurors' phones monitored? Their phones should not be. Their phones should not be. Social media activity and other public information is very likely. LSE said, EDB, can you now be selected for jury selection? That would be great. It would be terrible because I couldn't stream, but I would be fascinated. As a lawyer in the areas where I've lived, I can always be selected for jury selection unless the case was being prosecuted by my office. So when I got called for jury duty in LA, when I was still an LA district attorney, I could not sit on a jury that was being prosecuted by the LA district attorney's office. I could sit on a civil case. I could sit on a federal case in the federal courthouse or a federal grand jury, and I could sit on the city prosecutor cases and a lot of jurisdictions within LA County. How many different jurisdictions does LA County have? It's actually really complicated. But there's also city attorney cases. So if the LA city attorney or like Hawthorne city attorney was prosecuting something, I could be a juror on that case. Would the defense attorney keep me? Unlikely. Do I think sometimes I'm way more critical of a prosecutor's case than a defense case? Probably. Would a defense attorney assume that? Probably not. But yes, I could sit on jury duty, and I could sit on jury duty now. Lawyers generally don't always want other lawyers on the case unless the case needs that level of analysis. I kept lawyers on my case on rare occasion, and it had always been fine, but I also always felt like in their head, they were doing what I do. Like I would look at lawyer jurors and see them just like, and I'm like, oh, you think you could ask that question better? You probably can, but I'm the one standing up here who hasn't slept. So easy for you to say. And now I just do that on the internet. Easier for me to say, much easier for me to say, I'm sitting in my house. I don't have to go to court every day. I haven't moved. Like for a lot of the defense attorneys in the Karen Reed case, they've essentially moved across the country to live in a hotel for 2 months to do a trial. That's not easy. Much easier for me to say. But yes, I could see them sitting there going, Eric asked, EDB, pantsuit gal or skirt gal? Pantsuit. High heels before spinal fusion, flats after spinal fusion. There is a story that I have told, and maybe we'll tell it on members only again. There is a story I have told about where my pants and my high heels got me into quite a lot of trouble in court. That is for another story. That is for another day. Meredith in the chat asked, have I ever done jury duty? No, I haven't. I mean, I've gone to jury duty. I've never been selected to sit on a jury. So let's see. Thank you guys. I know we banged. It's so exciting. It's so exciting. Let's see. When did the tumblers come back? Michelle, the tumblers came back yesterday. We have a few left. And yeah, we have a few left. Laura remembers that a male judge commented on me not wearing a skirt more than once. I've also had supervisors comment that they believed that female attorneys should wear skirts, that it was more professional. And I was like, how professional is it if I just do this? How's that? It feels good to, I'm feeling good about it. I don't know how you feel about it, but I'm feeling good about it. It feels right to me. Yeah, no, yeah. Okay, I have thighs. Definitely not wearing a skirt. I had friends that did, friends that didn't. There are pantsuit stories galore, but no, it was It was definitely pantsuits. I mean, I didn't wear jeans. So it's fine. I get to work in workout pants now. Law is a profession that has norms that sometimes lag behind. I think there are times that lawyers would wear like really cute like shift dresses in court without a jacket. And there were judges that were like, you're not wearing sleeves. The horror. Am I that off put by arms? No, armpits don't I'm not bothered if somebody doesn't have sleeves on their dress. I am off put if somebody's like chewing gum or they're on the record. Like very, very off put. There are some decorums of court that are appropriate. Do I care if an attorney is wearing sleeves or not? No. Do I have my own decorum? Yes, I think there is courtroom decorum that is necessary to maintain the integrity of the bench. Do I think that gets to clothing norms the same way that maybe older school attorneys would? No. Do I think respect is still necessary? Yes, I do. What are we doing, George? I know your human's not here. It's hard. The way this cat loves my son. So, hi, buddy. Hi, buddy. Megan in the chat asked, can Karen get in trouble for her comments yesterday? Did she make them to the court? Did she make comments to the court? I don't know. I don't know if she said anything to the court. But she's not under a protective order. So I don't know. I haven't seen what she had to say. Truly, when I log off for the night, I don't even often get to catch other people's streams because we have stuff to do as a team. And then there's family stuff to do. She made comments to the press. She's not under a protective order, just the lawyers. So maybe now is a good time to reiterate and remind. I do not follow what's going on in the media and on social media aside of a case while the case is ongoing. It's really draining. There's a lot of it and it's hard. Karen talking to a reporter is obviously a pretty easy thing to discern, but there is so much that's unsubstantiated that swirls around when a case is going on. The mental energy to parse the facts and the fuckery is a lot. So I just stick to what's going on in court, unless it is something like, oh, they blew a fuse, or in the Murdaugh case, oh, everyone's been evacuated. Do you guys remember what happened with Alec Baldwin? And during the break, everybody was coming up with theories about what was happening during the break. And I'm like, we have to just wait. We're going to find out what happens after the break, but we have to just wait. There's a lot of swirling speculation, but it's exhausting. We will find out what's happening. We just have to wait. It was hard, but it works. So that's what we do. Because again, I'm not going to put out over the internet for hundreds of thousands of people to see something that I haven't verified. And middle of stream, I'm not verifying what's on social media. There were a lot of comments the day before Jen McCabe testified saying, Jen McCabe's going to testify tomorrow. I'm like, I don't know if that's true or not. And then the next day she testified. I'm like, great. I guess it was true. Perfect. Getting Grace, a question, will you cover Lively versus Baldoni when it goes to trial? I don't know if that's going to go to trial. Definitely not going to go to trial soon. It's not going to be televised. So we will see. It's an exhausting case to cover because of how many attorneys are involved and how voluminous the filings are. I am hundreds and hundreds and hundreds of pages behind because so much is going on in other cases. Wendy Lulu said, did they go on a view last time? Yes, they did go on a view last time. And yes, they did go on a view last time. Mar Palm asked a really interesting question because I'm going to answer it probably not in the way that it was meant. Who do you think has a stronger lead so far? Karen Reed has the presumption of innocence. She is presumed innocent until the Commonwealth moves that ball up the hill of reasonable doubt. So the Commonwealth starts at the bottom of the reasonable doubt mountain and tries to push the ball up the hill. The Commonwealth is not all the way up the hill yet for me, but they shouldn't be. They're not at the end of their case in chief. So right now we are at Karen Reed is presumed innocent unless and until proven guilty. And the Commonwealth is trying to push that boulder up the hill. So do I think that the Commonwealth has pushed that boulder up the hill yet? No. We'll see if they do. Jessica said, it's no Metallica. No need to compare and contrast. Music is music. I love the Bare Naked Ladies. They did parody of all the boy bands with choreography and everything. They threw macaroni at us at one point, 10 out of 10. Love the Bare Naked Ladies. I am a music fan. I like most kinds of music. There is some like scream rock that is maybe not what I would go see live, but I like a lot of music. Lori said, EDB, did you know that Recovery Addict pays the $3 a month for a Sirius radio station that only plays Dave Matthews? I know that Dave has a Sirius station. That doesn't surprise me. Never knew there were so many Dave Matthews lovers. If we grew up in the 90s, there's a lot of us that just love the Dave. Damn, I love Dave so much, but I also love going to see Metallica. My kid is also like, Slipknot when? And I'm like, we've got tickets to My Chemical Romance, buddy. Like, just, we're doing our best. You're also going to DCI all summer. So, Hello Awesome's at EDB. We need Corey Richens, not lively. We're covering Corey when it goes to trial. We need an update for sure. Beavis in the chat said, not a fan of Dave himself, but Carter Beauford is a stellar drummer. Carter is probably one of the best drummers of our lifetime. Carter is an incredible, their band is incredible musicians. I'm a really hardcore stan of Dave, so I have no impartiality on this. Carter's incredible. I love Stefan. I love that they've added Buddy to the band. I love the horns section. Jeff and Rashawn are absolutely incredible. So dude, when I see that massive bass saxophone come out, I lose my mind. I'm just like, everything that's going to come out of this horn combo is fucking amazing. You get that giant ass saxophone on stage, whatever song they're playing, and there's only a handful, whatever song that's coming is going to be fucking incredible. The second Jeff grabs that giant ass sax, every single time I lose my mind. And Rashawn was fucking singing at Jazz Fest. Come on. I love it so much. When Stefan gets up there solo, ooh! It's not often the Stone. They do not play it nearly enough live. It's often All Along the Watchtower. Ugh. Love, love, love. It's not Halloween nearly enough, but sometimes it is. My kid's first Dave concert, they played Halloween. I was like, are you fucking joking me? It's your first Dave show and they played Halloween. You can't go to another show. The set list was too good. You'll be disappointed. Oh, anyway. Millard asked, do other states have the hear ye's like Massachusetts? I've never seen it anywhere else. I've never heard it anywhere else. I had never heard of courts doing that until we got to Massachusetts. Each court has its own local quirks. And when we get to like South Carolina, their jury instructions involve reference to the cloak of righteousness. I live for it. I saw a couple questions about which corps my kid is with. He was wearing his corps gear on stream the other day. They have very fun hats. They are kind of known for their hats. We do not, he is not with Phantom Regiment. Phantom. No. So I'll go with that. The people that know the corps, but he was wearing his corps gear the other day when he walked on stream. So it's not really a secret at this point. And it's fine. I mean, it is. Rod said, my Foreo mask just arrived. Congratulations. So excited. That was fast. I saw a number of you mentioning in the chat today that you got your Foreo stuff and got your 30% off. Love, love, love. I was using mine last night and this morning. All of the things. Beverage on the lawn nerds at Metallica. Have fun. Jamie, thank you. I am not driving tonight, but I am very mindful. That I am streaming tomorrow. And knowing that I am streaming tomorrow, I'm going to have to get going now. Debbie says, my daughter and I are going to see MCR in Tampa. Saw them in New Jersey for 3 cheers. we are going to see MCR in Tampa, Debbie. So if you see me rolling around, just yell EDB at me and say hello, because I am also going to see MCR in Tampa. So I'm going to answer just a few more questions. Matt asked me if I saw the previous question. Yes, I just hadn't gotten there. Matt asked, in New Hampshire, the view was called the go-see and occurred before opening statements. Why do other jurisdictions view midway or at the end of trial? The start would have been better so jurors would have reference through the trial. It really depends on the jurisdiction. Why do jurisdictions vary? Because states are quirky and they all have their own legal histories. California generally called it a jury view. I have heard it referred to as a go-see, and they would often let the attorneys kind of negotiate with the court about when that was appropriate. It was not prescribed. It wasn't, you have to do the jury view at this time. I don't know if I would prefer a jury view before opening statements because there's no context to it. Like, here's stuff. It's like, okay, there's stuff. Like, if you go see 34 Fairview before opening statements, you're like, okay, there's a house in a yard, but you don't even really know what happened yet. So I think there's a lot of debate about when the right time to do a jury view is. Is the right time to do a jury view at the end of the prosecution's case before the defense case, when they've heard the prosecution's case and now they see where it happened, and then you get into the defense case? Or is it better to do it early in the case so they can visualize it? Is it better to do it at the end before closing arguments? I don't know when the best time is. I do like that they have the ability to do a jury view, because what you see in pictures or on video is not the same, especially when the size of the yard matters so much in this case. I think it's appropriate that they do a view here. They're not going to do a jury view in like the Idaho case. And now it's moved to Boise. It's really far away from where the crime location is. So why do different jurisdictions do it differently? Every jurisdiction has its own rules, and those rules can then vary by, like, there are the federal rules, there are the state rules, there are the local or county rules, there are sometimes rules beyond that, there are sometimes rules that are specific to a courthouse, and then within that courthouse, sometimes there are rules specific to just one judge. So it is like just a narrowing of all of the rules, which is why you have to get permission pro hoc to appear in front of judges in other jurisdictions, really to make sure you adhere to all of their specific rules. New York federal court does all the letter filings. Nothing's lined, everything's single space. It's so strange to me. And it's like a letter before a motion, completely different than how federal practice would work in Texas or in California. I mean, it keeps the lawyers on their toes. It really keeps the lawyers very, very busy. Melissa asks, can you explain how defense attorneys become special prosecutors? Is there a reason why someone would choose to do what Brennan is doing? I mean, you get paid to do it. I don't know what Brennan was thinking. I don't know if he'll ever discuss what he was thinking. I'd be really interested in what the thought process was. Like, no, but how'd this all go down? You can't really bring in a non-criminal attorney. And so attorneys that are practicing in criminal are either going to be defense attorneys or prosecutors. And you can't bring in a prosecutor from your own jurisdiction if you need to bring in a special prosecutor. And then prosecutors from other jurisdictions could also have conflicts, but also have their own cases. In Murdaugh, we saw the state prosecutors, the state AG's office, take the case instead of local prosecutors, but the state AGs also prosecute crimes like that. Not all state AGs prosecute kind of line level criminal cases. That also depends by jurisdiction. So not every state has the ability to bring in like a state attorney general prosecutor. We saw it in Murdaugh. We're seeing it in conjunction in Idaho. Idaho has the state county prosecutors and has brought in the state attorney general prosecutors. And then you've got federal prosecutors that are doing their whole own thing. So bringing in another prosecutor from outside the jurisdiction can be complex. So who does that leave in the criminal justice system? Well, defense attorneys. And a lot of defense attorneys had been prosecutors. We saw that with Erlinda Johnson and all of the other special prosecutors we've seen. How do they get selected varies by jurisdiction. And why would someone choose to do it? I don't know. It might be because they believe in the case. It might be because they, Emily, don't make a snark about 15 minutes of fame. It might be because they work with that DA's office a lot or had left that DA's office and want to take the case. I don't know, because I've never been in that position, because I've never been a special prosecutor. I was just a prosecutor who was very special. Ah, ha, ha. I couldn't help myself. I'm being hyperbolic. Special prosecutors, and I saw a lot of you asking, why would they bring in a special prosecutor? Because they are not using prosecutors from their own office. So a special prosecutor is someone that's just like deputized for the one trial. They're not hired by the district attorney's office. So they are not a district attorney. They are acting as a district attorney for this one case. And that's why they are a special prosecutor. But I'm waiting for what makes you so special? I know. We saw it in the Murdaugh case over and over. Rex88 says, the shortest straw has been pulled for you. I mean, Brennan can't get volunteered. He would have had to have said yes. I think there's probably reasons that they needed special prosecutors in this case. The chat, great questions, including Sarah JD. Who pays them? The taxpayers. Do they get paid more to do it? There's normally a contract, and that contract would involve payment, but not like the benefits and retire that a prosecutor would get, but the taxpayers would pay for that. Sometimes you have to get approval. I covered that a lot in New Mexico. We covered the process of getting approval for money to bring in special prosecutors. So how do they decide who to appoint? It depends on the office. I don't know how they did that in this case. It just depends on the office. So let's see. Ophelia, thank you for the comment. Have a blast, EDB. Thank you for your fair and fact-based coverage. I mean, sometimes my snark is maybe a little bit too snarky, but I always tell you where my snark is coming from. Just finished my first novel for MFA thesis. Congratulations. And your channel has frequently been my breaks and often in the background. Happy to bottle double with you. Congratulations. And yes, we focus on the facts. And if we're going to talk about the fuckery, at least we talk about the fact that it's fuckery. I hate it when fuckery is presented to me as facts. I'm like, stop it. Not facts. Anya said, did John O'Keefe sell a record? Did John O'Keefe sell record him flying when he was hit by Karen Reed's car? We have no cell phone data that indicates when that would have happened. I don't know what the prosecution's going to argue. Right now we have the 36 steps and then the phone being still. So we have not seen anyone asked about an impact event and how a phone would record an impact event. And if I'm a juror, I'm wondering about it. If I'm a juror that has a cell phone in my pocket, which I think all of them do, I'm wondering why I haven't heard that yet. Aren't you? You are, obviously, because you're asking. So we will see if they address it or not. I think they have to, because the jurors are going to wonder, but the jurors can only decide based on what they're told. So they can't speculate. So they can only use the information that they're given. But they also can look at those reports. Chat, I appreciate you. It is time for me to go. I don't think I'm going to get to recording the podcast today. Members, I will keep you in the loop. That's probably going to have to be Saturday. So I will keep you in the loop. I will be back Friday. Same hat after Metallica. So thank you for being here today. Thank you for being honored. I appreciate you. Thank you, mods. Thank you guys for the stream. It's time for me to go get ready for Metallica. I will see you guys on stream tomorrow. Will we be tired? Yes. Will it be fine? Also, yes. And, if you want to follow along with me on Instagram and the Lawnerd Lounge, I will be doing my best to update Metallica things. Last concert, I had terrible reception, so it might be after the fact. But a very tired Emily and a very happy Emily will see you tomorrow. Bye, Law Nerds. Thanks for joining me on this stream. If you don't want to miss a moment in court, you need the Law Nerd app at lawnerdapp.com. It's a free download on iOS and Android where I can keep you in the loop with everything happening in court and, of course, when the jury has a verdict. So if you don't want to miss a moment of this trial coverage, make sure you get the Law Nerd app. Thank you for being here, and thank you for being a Law Nerd.